Hi guys, it's Kathy. I hope you're doing well. We made it to the last part of this trial, and I hope there's an ending. Or I hope if there's not an ending, that there's an ending in a soon date. Like, I hope they say, okay, the next conference is going to be in January, because it's January 26th. Fletcher, I don't know. I say go for it. Go for it. Play all those shows. There we are. I don't know what in the world this is. I want to hope that it's another little group, but I don't know what that is. You know what? Maybe they won't say potty training at all this whole video. You never know. Could happen. Here we go.
Appreciate
We're on
the
the
parties
record.
have been canvassing, and we're now back on the record, and we understand a resolution's been arrived at, so.
Yes, Judge. So,
Mr. Freeman, please lay it all out.
well,
and we'll see if
for
there's-
starters, the parties have agreed, and we have discussed this earlier in the proceedings, but as part of this full and final settlement, they are going to share joint legal custody. And what I'm gonna do, I don't know, Your Honor, if you'll bear with me.
Sure.
I am gonna read those provisions into the record, what I would ordinarily not do, but just given these proceedings, I just
Oh,
want to read
indeed.
them. And what I'll even do, Ms. Hurd, is I will come, if Your Honor will permit me, to the latitude,
course.
let me come and sit next to Ms. Hurd so she can see as I'm reading. So, we're talking about joint legal custody.
All the statutory provisions?
Correct.
Okay.
Well, joint legal, so each parent shall cooperate and consult with the other in substantial questions relating to religious upkeep, if any, educational programs, significant changes in social environment, and health care of the child. Each parent shall have access to medical and school records pertaining to their child and shall be permitted to independently consult with any and all professionals involved with the child. All schools, daycare providers, and counselors, this is referring to school counselors, for the child shall be selected jointly by the parents unless otherwise specifically provided herein. All healthcare providers, including all medical providers.
What a
dentists,
coincidence.
Orthodontists, optical care providers, psychological counselors, mental health care providers, etc. for the child shall be selected jointly by the parents, and neither parent shall seek non-emergency health care of the child without the knowledge and consent of the other. Each parent shall be empowered to obtain emergency health care for the child without the consent of the other parent. Each parent shall notify the other parent as soon as is reasonably possible as to any illness or injury of the child requiring emergency medical attention, the location of any emergency care of the child, and the result of such care. Each parent shall provide the other parent upon receipt with any information concerning the well-being of the child, including but not limited to copies of report cards, school meeting notices, vacation schedules, class programs, requests for conferences, results of standardized or diagnostic tests, notices of activities involving the children, samples of schoolwork, order forms for school pictures, order forms for school and or club fundraisers, all communications from healthcare providers and the names and addresses, telephone numbers of all schools, healthcare providers, regular daycare providers and counselors, all school meetings, teachers, conferences, or any other meeting or discussion regarding the minor child shall be attended by the parents only. Now, if the parties desire, because I know this could be an issue, if the parties desire to expand parents only, they may do so by sort of written agreement, such as, we talked about Coco in the hallway. Ms. Anderson, if you at some point have a significant, a spouse who you wanted to include, you can always do that, but this is a bedrock. This is sort of the foundation. You can't fall through, you can't fall through the foundation of the house, but you can build a lovely structure on top of it, right? So this is the bottom. Does that make sense? Okay. Each parent shall advise the other of school, athletic, church, and social events in which the child participates. Each agrees to notify the other parent to make arrangements to attend the event if he or she chooses to do so. Both parents may participate and attend activities involving the child, including but not limited to activities such as open house, school and church activities, events, athletic events, school plays, graduation ceremonies, school carnivals, any other activities involving the child. We try to be as specific as we can. Regardless of which parent has custodial care of the child on the date of such event, each parent shall be afforded a reasonable time to greet, congratulate, take pictures, or participate in other normal activities with the child, acknowledging or memorializing the event. Obviously, reasonable is the operative word in both of these, but that is the case. Each parent shall provide the other parent with the address and telephone number at which the minor child resides, and each shall notify the other parent at least 10 days prior to any change of address of the child, and shall provide the telephone number of such address change as soon as it is assigned. Each parent shall provide the other parent with a travel itinerary and wherever possible telephone numbers at which the minor child can be reached whenever the child will be away from that parent's home for a period of 24 hours or more. Parties each acknowledge that they will need to share the child's passport and seek written permission of the other party for any travel with the child out of the United States. Parties further agree and acknowledge that they shall refrain from unreasonably withholding the child's passport and or written permission for international travel with the child when it is requested. Each parent shall encourage liberal communication between the child and the other parent, but shall not be controlled or interfered with by any third party. Each parent shall be entitled to reasonable telephone communication with the child. Each parent agrees to be restrained and is restrained from unreasonably interfering with the child's rights to privacy during such telephone conversations. Neither parent shall interfere with the right of the child to transport clothing, toys, or other personal belongings freely between the parents' respective homes. Neither parent shall disparage the other in the presence of the child, nor shall either parent make any comment of any kind that would demean the other parent in the eyes of the child. Additionally, each parent agrees to instruct their respective family and friends that no disparaging remarks are to be made regarding the other parent in the presence of the child. And the parents agree to communicate directly with each other regarding the needs and well-being of the children, and each parent further agrees to not use the children to communicate with the other parent regarding
Doctor, I'm so sorry about that. Come into Discord if you need to talk. That's horrible.
parental issues. The parents are mutually acknowledge and shall be bound by the terms and conditions of EDCR 5.301, which broadly prohibits the involvement or exposure of minor children to court proceedings and case issues within the family division of the district court. Okay, so that is, and I appreciate the court's indulgence, I know that was long. Those are the broad stroke legal custody definitions. We are also going to adopt, as part of our agreement here today, the department's standard holiday and visitation schedule. I've got Ms. Hurd a copy of that. I think you gave it to her early in the proceedings, but we have it again. What we're going to do is we're going to make sure that we don't need the Jewish high holidays, or the Jewish holidays is not an issue in this case, so we won't need that. And what we are going to do is we're going to, the delineation as to 3-day holiday weekends, what we're going to do is give Dad Memorial Day in even years, or excuse me rather, I apologize, odd years, I couldn't find where it was on the form, odd years, and then Mom will have Memorial Day in even years, and that way, it looks like in the court schedule, Memorial Day and Labor Day track together, we just split those up so that it's fair. I'll show you.
It also makes it easier to make three and
It makes it even, yeah, so all we did was, see how this is Mom, Dad, Dad?
Yeah.
All we did was go, Dad. See, so that way it doesn't, it's not together, where you get, each party gets Memorial Day or Labor Day in a given year, rather than them going to each parent both, okay? Yep, no, I get it, So that's what we're gonna do as far as the holiday schedule, with the exception of that. The remainder of the schedule is appropriate. The one carve out, it's not very much, oh, I see. With respect to Easter, Ms. Hurd has made everybody aware of the fact, myself and my client, that Easter is an important holiday to her, and she, as a result of these proceedings, et cetera, hasn't had an Easter holiday with the minor child in some years. So what we're gonna do is to make sure that the very next Easter holiday, which would be in 2025, in an odd year, so as to Easter Sunday, that will vest with Mom, and Dad will have even year Easters to Dad, right? So we're just reversing the designation on your standard schedule there. Do you have that, Ms. Hurd? The exception to that, this will be incorporated into a final order that I will prepare. What we're going to do, as we've already addressed legal custody, so that's been appended from the court's original order to joint legal, we were gonna have a designation of primary physical custody to Mario Perry in this case, subject to essentially a 5-2 timeshare. And the way that will flow is as follows. Ms. Hurd's visitation in week 1, so it's a week 1 schedule, Judge, and a week 2 schedule, okay? So the week 1 schedule, Ms. Hurd will have custody of the child from the time school lets out, approximately 3 p.m., through Friday at the conclusion of school, meaning Mr. Perry will collect the child from school.
Tuesday from school to Friday delivery to,
Wednesday from
oh, Wednesday.
Wednesday after school till Friday after school. Okay? And then in week 2, Ms. Hurd is going, and Mr. Perry will have custody of all other times not designated in the week 1 schedule. Week 2, Ms. Hurd will have custody of the minor child from the time school lets out on Friday, approximately 3 p.m. and will conclude on Sunday evening at 8 p.m. So effectively, she will have every other weekend for a full weekend, and she will have the 2 overnights in the weekdays during the week one schedule. Mr. Opari, again, will have custodial time at every, any other day not specifically referenced. With respect to, the housekeeping issues, we have the parties' financial disclosure forms on file. We're just gonna have a standard, NAC calculation on child support based upon the income set forth therein. I've discussed with Ms. Hurd and, her, her
Friend?
associate friends,
My
that
expert friend.
the way that the law works and that we have a standard, 3-year review on
My
child
expert
support,
friend.
that, on a change of circumstances, there's a basis to petition even within the 3-year look-back period. All of the baselines in terms of modifications of custody, the standard is Romano. If we need to address a custodial issue before the court, that's what the court's gonna be looking at. And, in large part, I think that both parties compromised here. I think that they did so in recognition of the fact that Aslan's best interest, as Your Honor, I think tried to point out a number of times to both of them, Aslan's best interests are served by putting a long amount of litigation behind them and focusing on the future and focusing on doing what is best for her. And I applaud both of them for doing that. It's not easy to do when you're as dug in as these parties have unfortunately had to become in this litigation. So I think they should both be applauded for that. With that being said, Judge, Madam Clerk, would we be able to swear the parties in, and that way I can?
Aren't they both under oath from prior?
You know what, Your Honor, I don't know. I thought maybe.
Yeah, they are, right? They were sworn in.
I'm sure they are.
Yeah,
If
they've been
the
sworn- they've been
parties
sworn
would
in,
like
yeah.
to be resworn.
Darn it.
At the inception, I'm fine with
I think I put the wrong video on. Monica's right.
it unless you want them resworn.
I would stipulate that Mr. Perry is under oath. Ms. Hurd,
Okay.
I believe you would stipulate
Yes.
that you remain under
Yes.
oath? Okay, all right. So, just briefly, Mr. Perry, you obviously heard, you know what, Your Honor? I would be remiss if I didn't address it, although my client might not have been frustrated by it, but I'm assuming Ms. Hurd, you would have caught it.
And you just said it, yeah.
My client, Ms. Hurd has presented a proposal to my client. It's not technically before the court, and it's something that my client and I had to talk quite a bit about because he was not exactly keen to the idea. But in the spirit of compromise that I just referenced, Ms. Hurd's request was that the child's name be hyphenated from simply Perry to Perry-Hurd. Discussed this with my client. Again, while he's not a huge fan of the idea, he understands it's what is best to be done here today. So we are going to, as part of this order, include a provision that allows for the minor child's name to be legally hyphenated. We did discuss.
And studies do show that it's in the best interest of a child bonding and keeping that identification with both parents
You
and.
and I you did discuss, Ms. Hurd, but I want to just make this clear for the record, that we're going to do that. But I think what you said, and correct me if I'm wrong, was that you weren't looking to use that in a way that was going to cause problems and make a bunch of people change their records and kind of, but that you just wanted to know that it was done, and then obviously you would be free to use it.
I agree with this decision 100%. And I'm glad they're doing it.
Hyphenated name, and know that that was her legal name, correct?
And she knows that it applies to her and how she chooses to use
I-
it as I'll let her choose, but so that she can identify with both families.
100% understood, just so we know it's not something where, as I understood from you, we're not gonna all of a sudden now go to every single entity that has her and demand that they immediately go about
I'm not gonna
redoing
demand.
all of their records.
I will let them know, and how they choose to proceed is up to them.
And I would hope that extensive to that is that we're not going to have a slew of conflicts resulting if,
No.
let's say, they don't immediately update something, that it
No,
turns
no, no.
into, that's all.
Right.
That's fine.
Just wanted to be clear it was done because it was important to you and you
Right.
felt that the child, and that's okay, we just didn't want it to spurn
That doesn't
additional.
mean immediately this next month that I'm gonna
Right.
enforce it and have everybody refer to her that way, otherwise all else. As long as she knows and it's legally, that's her,
That's all.
that could be her decision.
That's all we were looking for. I don't know that it was originally in the order or not. I'm assuming Ms. Chrome, when she prepared the order for trial, may have done this, but just to reiterate, we're going to have healthcare costs covered in such a way if the child remains eligible for Medicaid, then obviously it's a no
And I
cost.
will lie, because I probably may qualify, and then I will.
But obviously
She has Medicaid.
it's
I
no
know,
cost.
but
It's a,
Yeah, she qualifies.
as long as she continues to qualify, it will be at no cost. Obviously, both parents will have the ability to use that health insurance to the extent that, for whatever reason, at some point in time, Aslan no longer qualifies for Medicaid. then the parties will obtain a private insurance policy, whether that be through one of their respective employers or simply a private policy. They will get the best policy that they can while being mindful of obviously the overall cost of that policy and look to do that weighing. They will then split the monthly premium 50-50 in addition to any.
Yay,
obligation. And
doctor,
then with respect
welcome.
to unreimbursed medical expenses, a pretty standard provision, and I know it may have been in your honor's orders, would be a 30-30 rule. And what that provides, just so it's there for the record, is that if a parent takes a child to a doctor, to a pharmacy, to any type of medical provider, and there's any type of copay or out-of-pocket cost, and that parent would tender that out-of-pocket cost, 100% of it. They would then seek reimbursement by providing proof of the payment and proof of the cost to the other parent within 30 days of the payment. And then to the extent that there's an objection or whatever, that can ensue, but within 30 days it must be resolved. The other parent must, within 30 days of receipt, tender payment for 50%. And that is a 30-30 rule. And we were going to keep that in place as the operative order of the court. I think that covers everything in our comprehensive deal, and I apologize that I didn't get to that beforehand, because I did want to end on sort of the comments to the parties. Being that you are both under oath, Mario, I would first turn to you. You've been sitting here throughout these proceedings. I know that there's been a lot involved. I know that there's been a lot of emotion, a lot of conflict. But I guess first and foremost, you're prepared to move forward today on a clean field, are you not?
Yes.
Okay. And you've heard the terms, both the legal custody terms, the custodial designation, and the timeshare that I placed on the record, correct?
Yes.
Okay. And I've explained each of those terms to you. Okay. You understand each of those terms.
Yes.
And it's your belief as we sit here today that on balance, in light of where we've been, those terms, if the court adopting those terms as the binding and final stipulated orders regarding custody of Aslan, that those orders are in Aslan's best interest, right?
Yes.
Okay. And you would ask that the court adopt in totality these terms, both sort of verbally here today, and I will ask him to do so pursuant to, it's no longer 750, Judge, you'll have to remind me of the new 750, I can't recall it. But, not only verbally, but the judge will actually, sign off on a written order to that effect, and you want to be bound by those terms, correct?
Yes.
Okay. Now, you're aware of the fact that by a stipulated resolution, what we're asking the court to do is we're waiving the rights to findings of fact today, we're waiving our rights to conclusions of law, and we're waiving our rights to appeal, meaning when we're done today, we're done. The judge is not going to have to make findings and issue orders. It is a stipulation of you guys. You understand that?
Yes.
Okay. And with that being said, if I can canvass Ms.
Please,
Hurd briefly on the
please.
scene. Ms. Hurd, you heard a lot of the questions I asked. Mr. Perry, and Mario, sorry, I should ask this just since it's formal. You're not under the influence of any drugs or alcohol here today, correct? Nor ill in any way that would impair your testimony?
No.
You're competent to answer the questions that I previously asked?
Yes.
Okay, Ms. Hurd, same set of questions?
Yes.
You're competent to
Yes.
testify? Wonderful. So you've heard all of the terms that I placed on the record as far as legal custody, correct?
Correct.
Okay. And you heard the terms regarding physical custody designation,
Correct.
correct? And the timeshare of your minor child.
Yes.
And you believe each of those terms to be in Aslan's best interest.
Yes.
Okay. And you would ask that the court adopt those terms as its order once we submit it to the court for final decree, correct?
Yes, I do.
Okay. And you understand, like I asked Mr. Perry, in a stipulated resolution, what we're waiving is the rights to finding of fact, conclusions
They
of
keep
law,
the Friday.
and to take appeal. Okay? You're aware of that fact,
Yes, I
correct?
am.
Okay. And you're willing to be bound by the terms with those
Yes,
reservations,
I am.
with those waivers in place,
Yes,
correct?
I am.
Okay. So, Judge, I don't even have to ask you to look it up because I have a legal genius
Perfect.
over here who has found, we would ask, Judge, that pursuant to EDCR 5.601D, that the terms placed into effect today be the binding order of the court, effective immediately. We do understand, Judge, that that order needs to be reduced to writing and presented to you, which I will do. I will also get that to Ms. Hurd prior to submitting to you. I will get it to you, Ms. Hurd, with a 7-day review period. If you can get me any comments.
And I sign off.
You would sign off, and then prior to me submitting it to the court, we would both sign, and then I will submit that to the court for a signature. But we are agreeing to be bound by these terms effective immediately,
Right.
under 5.601D, correct?
Yes.
Mario, correct?
Correct.
Okay. And to that end, Judge, what we have discussed is because it is Wednesday, and because Ms. Hurd's schedule would follow from today, and we've checked that with Carrie's schedule. And,
Yes.
Okay, wonderful. So then her time will actually commence today. So she will be able to leave here. We're gonna have a short conversation about just some house, how-tos, and when she leaves here today, she will collect Aslan to start that time, so it is important that the order be effective immediately pursuant to 5.601. Okay, Your Honor, and with that, I would submit to Your Honor.
Very good. Did you have anything additional that you think?
I just wanted to specify her, and I'm really hoping, I'm willing to, Mr. Perry, move forward and put the past in the past, and from today on forward, move forward. I know there's a lot of hurt, and I don't wanna fight with you. I want to be the best co-parent for Aslan that we could possibly be.
Absolutely.
All
And
right.
along those lines, if you want to suggest in the future something for them, if they call you a parenting coordinator,
My
a
thinking is, I didn't
post-custodial
broach this, but
counseling
here
or
would be
something.
my thinking, and that's a
Yeah.
very good idea, Judge. What I would append to it, I know I said submitted, but let me pull it back for a brief moment. What I would suggest, if you guys are both amenable, is that we have a mandatory mediation provision put in place. What that would mean is that before either of you runs out and files a motion, okay,
For anything.
for anything, okay, that we agree that you guys will request mediation.
Hi, Bill.
From the court.
Bill's here, guys.
When that request is made, I'd be happy to sign it, and then you guys can sit down and at least explore the mediation process.
Okay.
Is that amenable to you?
Yep.
Is that amenable to you, Maureen? A lot of times, I can tell you my experience is, even just the cooling off process involved in that leads to clearer heads for everyone, and it's much more likely to result in a resolution that you both are stipulating to. Okay with, rather than we're upset and we gotta file something immediately while we're still hot. Does that make sense?
Yes.
And I tell clients that too, even though it is counter to my financial best interest, I will tell clients all the time, take a beat, cool off on this, think about it, because once you jump in, you're in it, right? So I think it's a very good provision.
I agree.
Okay, sounds like everybody agreed, Judge, I will come back to you, submit it to Your Honor.
Very good. And I would mention, because sometimes parties look in the mirror endlessly at these hearings, should have I settled, would have I done better or much better if I proceeded to the decision. So with the understanding anything can happen in the remaining day and a half, there could have been game changers, the court keeps a totally open mind, something could have affected the court during the remainder of today or tomorrow that would have changed this perspective. But where I stood now, if the case had ended now and the court was forced to decide, it's eerily similar to what the parties agreed to, which is good that everyone effectively read the lay of the land. Week one, as far as I can tell, would have been virtually, if not identical, to how you two arrived at. Week two would have been the same, possibly the court, for times that school, if and when school is in session, keep overnight from Sunday to Monday morning. But aside from that, and that's something you can talk about in the future if practical, but.
Long weekends, obviously.
Yeah, but that it's eerily similar to what you guys arrived
I
at, which
suspected
is
as
sort of
much.
a,
I suspected as much.
yeah,
So,
so, maybe, so the answer is, yeah, you should have settled, because it wasn't gonna, neither side was gonna do dramatically better or dramatically or worse, or even notably better or notably worse than if it had settled. The only possible difference would have been this keep over from Saturday to Monday morning, on week two. Aside from that, it was a flawless reading of the situation, so.
Thank you, Judge, and Ms. Hurd, thank you for your cooperation. Mario, thank you. I will, in earnest, work to prepare this order as quickly as I can. I will get it to you for the countersign. Once you've done so, we're gonna plan for 7 days. Once you have 7 days, if for some reason, but if you did, you know. but
If it's
otherwise,
what you
that's what
said, it
It
will
is
not
gonna
be
be.
7
It's
days.
gonna be what I said, and we'll get it to Judge. You can sign it, and we can conclude this matter, and hopefully, while I will still see you, Judge, I will no longer see you on this.
True.
case.
And it's suggested here is some discussion of the parenting plan. I haven't modified.
Granny Squares would be a great way for you to end your endless boredom on your trips when you're with your band. Just saying.
That in 15 years, and that's one of my New Year's projects, resolutions, so I need to start with. So any suggestions attorneys or litigants or anyone can make on, as to that, please
You mean the
Sent-
holiday, the standard
Oh,
holiday?
yeah, oh, everything, yeah, pretty much about the standard, this holiday plan,
It was
yes.
just, the only thing we
The
noticed,
standard
Judge,
holiday
was just the Labor Day and Memorial
Right,
Day
that one.
are the same, that's the only piece.
And someone else noticed that not long ago, so I have that on, it's good.
And for both
reminder,
parties, right,
yeah.
because it's, you know, if it's your year to have both, you feel pretty good, but then when it's your year and you don't get either, you're bummed out, you know what I mean, so that's why we.
So I don't have to totally revamp it, but
No.
after 15 years, I should be, I
It's
should
pretty
fine
good.
tune
That's all you're
it, I
dealing
should
with after
fine tune
15
it a
years,
little bit,
yeah.
you know, so. Well, but it's great, as you mentioned, you got this done into Aslan's 8th birthday's next month, so it's great, it's done in time for
I
that.
appreciate it.
You bet. Best of luck, guys.
Thank you, Judge,
Thanks
very
so
much for your
You
time,
bet.
Marshall Long,
Thanks
thank
so
you
much.
as well for your
Best of
accomplishment.
luck.
You as well.
A very, very large part of me wants to just end this right now because we came to a conclusion. Did we not just come to a conclusion? But we didn't come to a conclusion because there's 3 more videos. So whatever just happened, it gets undone. Hold on. I'm going to show him a picture of some granny squares real quick. There's our granny squares. All right, here we go.
Thank you.
Go on the record, I'll tell you this, Hurd, Mr. Friedman is here with his client.
Thank you, Judge.
Ms. Hurd is here. This evening, a few observations, not the least of which is, I can't really, virtually no idea of how to proceed from here. I'll lay out my dilemma. First point was the recusal of the court, which the court attempted but was rejected. Now, we can circle back to this one. The good news on that is if the court could viably attempt that again, because it's not as if the chief judge rejected the recusal for this court not citing the right rules or it not fitting into the category to generate a recusal. It seems to have just been recused by the reassigned judge who did not seem to want to inherit a very intense, voluminous case and thought it should remain in the original department. So that can still be attempted. But then number 2, my concern, what are we supposed to do? Start all over? What are we supposed to have, 6, 12 new evidentiary hearings where we already had several? The parties brokered an agreement. Now, I mean, I do have notes on those hearings, but we'd essentially, after all this time, have to start over, and it would be probably submitted that things have, which it is, that things have changed a lot since those evidentiary hearings anyway. And which leads to number 3, we've got a gazillion new motions filed at a frenetic pace. I assume to the extent they would need to be, yes? I'm sorry, I assume to the extent they would need to be heard, they would be combined with the overall evidentiary proceedings if there needs to be a do-over. But number 4, I think we're going to have a hard time proceeding with anything if we thematically have a dramatically different life view on what's occurring or human behavior. In other words, these parties brokered a deal, understanding each other is fit for pretty much a shared parenting situation. If there's specific instances like the ball game and some other instances which angered us, which could have been handled differently, how does that somehow morph into something where we're so blinded by anger that we think that changes the reality? In other words, if we're having trouble with another parent who we've been parenting with and we cut a deal with to co-parent and to share custody to a large extent, because there's an unfortunate instance or two, how does that mean that overnight the other parent is unable to care for or adequately feed, love, and raise and educate a child or attend their medical needs? But that's exactly what we're getting now, because these two have had an unfortunate instance or two, which I made very clear could have been easily avoided, and I let it be clear in my last order how I would have expected it to easily be avoided. Nevertheless, how does
I bet your dad got yelled at a lot in that last order. I bet your mom was the one misbehaving.
that transform people into bad parents when we cut an agreement where we agreed that parties could co-parent. Now, we getting, and not even combine all our complaints into one motion, but separate motions now. What's the motion for tomorrow, next day? This person posted something on social media, or the next day, I don't think your car seat is good enough. I mean, this is a runaway train.
Judge, I think I can.
Good, because I'm not
simplify
willing
this.
to
I
do
think-
another 6 or 12 days
I
of this,
think
and
it
if
would
you
be-
guys want that, I'm gonna
No.
try and recuse
Judge,
again.
I think it would, first of all, I think it would be unlawful, and second of
sorry?
all, first of all, no, I don't think we need that. A.
Good.
B, I think it would be unlawful and contrary to the law. So I think.
Well, there's that
There's a
too.
very simple solution here, okay? As your honor is aware, we conducted a series of days of an evidentiary proceeding that candidly, your honor was generous in even setting based upon the remand. I think you could have simply said amended findings, but we did the dance, okay? We came in, we negotiated in good faith, and we not only reached an agreement, but we proved that agreement up under oath. And then more to the point, we stipulated to make that agreement effective that day in order to more quickly facilitate defendant getting the additional parenting time. So I were in custody to my client, but she went from very limited to essentially a couple days a week, right? So the bottom line is everybody was here, everybody averred to the validity of the deal was in the child's best interest. I took some painstaking, I wasn't here at the last hearing, I wish I had been, but I went through painstaking detail to place all of the terms on the record, okay? We provided that to the defendant, we gave her a considerably extended period of time to respond. She did not. We followed up. She still did not respond. At bottom, we then submitted to the court. The court signed off. The only, and I say only in the most judicious way, the only singular complaint that defendant has that I think is remotely valid with respect to that is that when it was finally submitted to the court, not when we first sent it to her, not when we followed up a myriad of times to get it, but when it was finally submitted to the court, she was inadvertently omitted from that email.
I'm sorry,
She was inadvertently omitted from that email that went
Oh.
to the court, okay? The court still nonetheless reviewed it against the records, the minutes, the video, and found it to be accurate. So.
I'm sorry, did she ever, after that, send you any emails indicating
No.
any part of it that's not consistent with what occurred on the record?
To my knowledge, there is no objection that she has to the
Just like that
substance.
on May
Ms.
31st.
Hurd.
Okay, we'll get to her.
Okay, he's gonna lie again, so let's do this.
Okay, so Your Honor,
Come
I'm
on,
trying to
guys.
make your life simple, because last time when I
I
watched the
lied.
video, okay,
Come on, guys.
last time when I watched the video, what was apparent to me is that Your Honor was frustrated. And you were frustrated, and I certainly can understand that, because I see what you see. I see a litany, something like 15 filings by Ms. Hurd following that June prove-up, and you had a sense this is never going to end. Well, Judge, I agree with the sentiment that Ms. Hurd may never be willing to stop, but you uniquely have the power of the robe, and you sit up there for a reason. You can bring this to an end, okay? So if the only thing I understand she has an objection to is the way that we calculated support based upon what she showed as her income, okay? But the substance of the timeshare, the holiday plan, the legal custody agreement, so on and so forth, not only were they accurate in the order, they were put on the record in open court. And we cited in that order to minute marks to where those orders came from. They are irrefutable. So if Your Honor wanted to be as lenient as possible, I would say you can give Ms. Hurd 7 days. Let her review the order, and if she wants to send me within 7 days a specific page and line number that deviates from the express record that was put on the record, that the court approved and ratified that day, and it was effective that day, so that she could receive her parenting time. And if there is a wordsmithing error or something of that nature, Judge, I will certainly correct it, but I can almost assure you that will not be the case. With respect to child support, my attitude would be, the order is the order. If she takes issue with the calculation of which I think she's claiming her business expenses or something like that, she thinks that we were using a gross rather than an adjusted gross, right, income, then certainly she can relay that within 7 days, and we can look at that. Notably, Judge, whether she agrees that support should be X or support should be Y, she hasn't paid $1. So, okay, well, that's my position. Now, with respect to the serial file, so I think that's what Your Honor either enter it as is, deny her motion, set aside. I think you should deny her motion, set aside, period. Okay, there's no basis to set the motion aside, and you stated as much at the last hearing. And if you look at the briefing, you'll see very clearly, there's no legal basis to set this order aside, okay? If it's a matter of a specific page or line, as I said, she can provide that. I doubt that she'll be able to do so, but if it's there, if we departed from the record, it can be corrected, okay? But I don't think there's any basis to set aside. And then I think what you need to look at, Judge, strongly, is the concept of vexatious litigation. And last time I wasn't here and I didn't have the benefit of being able to make arguments, but I can tell you that it occurred to me that this court had some sense that there was parity in terms of what was going on, that my client was filing and that she was filing. That's not the case at all, and that is belied by the evidentiary record, okay? And so at some point, Judge, Ms. Hurd is a bright woman. She has...
I don't think my concern was he was matching her with filing. My concern was that when I told him obviously how that ball game issue should have been resolved, he seemed to take real issue and defend a confrontational approach that he knew could only end very
Well, my
badly.
understanding of that, Judge, is that your concern was that he should have allowed a photograph to be taken by somebody who he didn't want
And,
to.
yeah,
But
more
then
to
he
the
removed
point,
himself
and
Judge.
when these two were right up against each other, he should have wedged himself kind of gently in with his back toward her and spoken to his wife and said, "Hon, go sit on the bleachers."
But I think what he did was remove himself, and it was uncontroverted at the last hearing. Ms. Hurd stated on the record that she followed them out. And so they're removing themselves from the situation.
We
But
haven't
again,
had any repetition of anything like that, right?
No,
Okay.
no, and we would like to eliminate, to the greatest extent possible, these parties needing to interact on that level, okay? It would be wonderful if we could build a beautiful crystal house above the basement, but it does not seem likely in this scenario. But, so I would say that I think Your Honor may have had a misapprehension based on maybe how it was presented to Your Honor, that my client did anything other than what I would have told him to do, which is if you don't want to engage with another third party that's being, forced upon you, then remove yourself from the situation, which he did. And Ms. Hurd's own statement last hearing, she then followed them out, right, as they're trying to leave. I don't know how that
The police
falls
were,
in my hands.
it was reported to the police.
Well, I think both reported to the police, but it was, the
Still open
incident was when
investigation,
she
Your Honor.
followed them out, when they're leaving the field to get away, and she told Your Honor, well, I
There was
followed them
no
out
open
because of my-
investigation. If they show up at something like that, they either arrest someone, or if they don't, they say, if he's gone or you're gone, someone can still file a report. If they've done nothing for months, they're not gonna, as a practical matter, I guess there could be
And so
exceptions.
this is my last piece, Judge.
That's
when we
how
talk
these
about-
things are.
We talk about recusal, so I do not believe that there's any legal basis for another evidentiary hearing. The orders were put on the record, proved up, and binding that day by stipulation, okay? The fine print of that order was circulated. Ms. Hurd did not respond. If she has an issue within 7 days and wants to present with the specific wording in that would be fair, because we truly should have, not that she didn't have notice, but inadvertently left her off the email that went to the court, notwithstanding the court checked it itself, okay? But that's fine. We 7 days on that. If there's a financial concern on the week, child support's calculated, and the belief by Ms. Hurd that, the gross income should be reduced by whatever she believes her business expenses are, certainly she can put that in writing.
Did
to
you
me.
receive anything about that?
She's made representations, right?
I filed the P and L, they never asked for any documentation.
What did she tell you, the support that she thought she should pay based on her calculations?
I mean, you can, I don't have that number in front of me, Judge, and quite honestly, it's,
$140 a month minus
Ask her how much
what
she's
he gets
paid.
for SSI.
ask her how
Which
much
means
she's
what?
actually paid. Because the answer is, whether it's $700 or whether it's $90, she's paid zero.
And I
That's
can
true.
understand that.
There's arrears, there's child support arrears that this court has not addressed, and that's also a concern, that's why I want this
I
motion
don't-
to be set aside.
I don't,
Because there's property and financial issues
We've
that
heard
have
about
not
that a
been
lot.
addressed
Was
that were
there ever
filed
an
in the
order,
trial court that
is
this
she
court
referring to
failed
some
to
order
refer.
from long ago where he didn't, might be proper for the DA to crunch this all together, where he had a support order he didn't pay, or?
Yeah, March from 2021 to December 2021. This
Okay.
court never decided on
Okay.
that, and that's
I
still
think I
out.
said a gazillion
Arrears.
times that if that's appropriate, it can be credited against her future support that she's to pay. If that's the
I mean,
case.
I would also
And
remind you.
there's tax, there's still property, there's a car.
Why would there still be all this after all this
They
time?
were never
Because
married,
this court
Judge.
has never addressed it. My
How
main
could that be it
concern
was
is the
never
safety of the
addressed?
child,
They
not
were,
money
they
and
were never
property.
married.
Pardon?
They were never married.
But this
Well,
court
that
has the
explains it.
I don't
jurisdiction
even know
No, it
to
doesn't.
oversee that, and I just figured that
I
out.
suppose it does if you stipulate to it, otherwise it's a separate,
Yes.
unless
Right,
you
which
stipulate
I
the
just
court has
figured
the
out,
authority.
this court does have in fact the
No.
jurisdiction to
No,
oversee that. It's
that's
in my
not a
trial
complete,
brief filed
no,
January
not
6th.
true, unless, it has the jurisdiction, comma, if the parties stipulate to it, and even in those instances, that's a highly debatable premise. But at least,
And the landlord
at least
pays
it's a conversation we
discretionary.
could have if they agree to it, but
I couldn't even tell you what she's talking about, but to make your life easy,
course, you
Judge.
never-
why didn't they just get married if they wanted to divorce and have all these rights?
Right.
The court is not
Agreed.
supposed to do this,
I
and that if
absolutely-
they
I
decide
stand by
not
my
to get
decision
married.
to
I'm
never
pro-
be married.
I am prohibited,
Jesus,
if you
I
guys
was
don't
married.
want the protections of marriage and the responsibilities and rights which flow from the divorce, which comes from it, I can't just impose that and do what I want.
Ultimately, I only care about the child's safety. That's my
So-
utmost
Okay,
concern.
okay.
All this property and money, I'll push aside.
Well, that's
I only
fine, then,
care about her.
okay,
That's
fair,
who I care
fair
about,
enough,
right
before
there.
we get too noble, they didn't mention it, you're emphasizing it, and when I say, I don't have the authority, and then you say, it's not what it's about. So, okay,
So
fine,
my
let's
last-
deal,
my
okay,
last piece, Judge,
let's
very-
deal
very
with,
briefly.
let's
With
deal with the
respect to-
child, let's
with
deal with
respect
the,
to-
Mr. Friedman's line,
let's deal
we'll
with
keep
the
going
child,
there.
let's deal with the
I would
child
ask the
support.
court to
Hold
advise
on.
Ms. Hurd about
Thank
this
you,
comment.
let's deal with the
Go
child,
ahead.
just-
Way you can win.
let's deal with the child support. Okay, let's start with, the purported arrears period, which consisted of,
Joint custody from March 2021, Mr. Stoffel filed this. This is
okay,
in a
March
complaint.
first,
This
two
is a
thousand
counter
twenty-one
complaint.
to when?
December 2021.
He was under a support order.
That's not
You
my
should have
understanding.
been.
It's not, well, that's a very different, that's a very
Yes,
different statement.
we
Judge.
were, that's when he filed in March 2021.
It's not accurate.
My complaint is that we had joint custody.
There was a support order or there wasn't?
There was
There
never
a
one made.
support
This
order,
court never
Judge.
made one.
Okay. You can't say what it should have done 3 years ago when support was
You
set.
can
How
because
did
your,
this-
your
no,
court, your
no,
Your
no,
Honor, you went to the
It
Supreme
doesn't, you
Court
know,
regarding
how long ago was
arrears
this,
just
how
3
long
years
ago was
ago.
this initial order
You know that.
issued? How long ago was
This is
this
a matter of this
Thank you.
court.
Are you
How long
referring to the
ago-
original decree of
No matter
divorce?
what the court says, it's gonna be 3 or 4 years ago, you should have done this.
I-
Even if I then determined that they submitted stipulations
You
on all
have
these
the
things.
power
We never
to
did.
stop. You have the power to stop
Okay,
it.
what happened, what support order was supposed to be established
there
that I
was-
was asked to
We had
establish?
joint
3 years ago?
custody from March 2021 to December 2021.
Do I have to, are you guys gonna answer, do I have
There
to
was
go
no-
back and
there
look?
was no support
How did this
order,
all
Judge.
There
originate?
should have been.
That's, do you see what's happening, Judge? She's claiming that because she in her mind believed that for a
It's not my
period of
mind,
time
it's
there was
the
joint
law.
physical
What was-
custody.
It's the
what was the-
law of the state
what
of Nevada.
admission-
What she's.
What
understanding.
initially happened here with the support or lack thereof?
What
Who had
she's-
the child during this point?
what she's
We both did.
Okay.
stating, Judge,
Okay.
is is a circle, and I'm trying to make this simple for you.
Mhm.
Please
I
stop demeaning
promise
me,
what you're
Mr.
doing.
Friedman.
What?
Stop demeaning me.
Okay. Judge, what she's trying to tell the court, as I understand it, is because the state of the law was, prior to the initiation of the case, or even
There is, because at the beginning she said, okay, we are on the record.
once a case had been initiated
21.
before an order, is that the status would be joint. And so based on that, there should have been, she's saying, an order for child support based on the fact that they had de facto joint. But there was no support order entered. That is the argument she's making, and it has to fail legally, and your Honor's well aware of that.
It will.
There's simply no
It won't
basis.
fail in Supreme Court.
Okay.
I'm-
That's fine.
And again, Judge, this is the emboldenment that I think that you have the power to correct. What you said at the last hearing, I think, was incredibly.
Where is it in 2021 when this was filed, that someone was before this court insisting on a support order?
So in the counter complaint, there was,
Yeah, I noticed the.
Take my money.
noticed the request. Where is the first order that occurred in this
Never.
case?
it never did because they were,
Order.
the court was entrusting the council to do such and they never did because of SSI payments. And SSI payments cannot be considered. There's state law, there is US
Okay.
Supreme Court law that says you cannot consider
Okay.
SSI payments as income. And that's what I
Okay,
was
fine,
arguing.
okay, fine. What is it you're looking for in terms of current support?
Honestly, we're getting nothing, and that's not even, we want to be done, Judge,
Okay.
candidly.
I want
So,
to be done,
at
but I
bottom,
want my child to
as
be
I said,
safe.
the order
Then why
should-
don't you offer, you're not
order-
asking for current support for those 9 months?
Order should
uh,
stand.
There's no arrears for those 9 months and she doesn't have to pay current
I
support, at least.
believe, Judge, as part of the original, as part of the prove-up, we waived years of arrears.
Mhm.
When we were in front of your court last time for the trial.
How am I supposed to know during this 9 months who should have been paying what?
Wait,
What was the custody arrangement during those 9 months?
I'm so,
Joint.
I'm confused.
Okay,
Judge.
joint. What were they both earning during those 9
I had
months?
Judge, what are
SSI.
we talking about
He had
right now?
75,000.
I'm incredibly confused as to what we're
He
talking
is
about.
Well, you're
always
not as
confused,
confused
that's
as
not
I am.
shocking.
Ms. Hurd is trying to argue.
I'm celebrating Australia Day today. I am, because I feel I'm part Australian with all you people in here telling me what, oh no, I can't remember what they're called now, zipper walkers or something.
That dating back in 2021, she thinks there ought to have been a support order. And because there ought to have been one in her mind, you should now offer some evidence.
I'm trying to
about
just see
future
on
support.
this issue before moving to the next, which apparently the answer is no, whether we can have a sensible dialogue or a sensible resolution.
I don't
My
think
client's
we can.
position
I
is he
have
knows
sent
her- he
numerous
owes her
letters
no back.
trying to resolve this, and I get completely
Well, then,
ignored.
is he honestly seeking to gain support from her, or does he want to keep fighting endlessly?
He's not receiving any money right now, Judge. I
Is he
think-
willing to accept that reality? If he is, maybe we
Well,
can
the
come
judge,
to an
you
agreement.
have the power to simply put, I mean, sure, my client could give up the whole ballgame. He could walk away and hand his
No
child
one's,
over
no
to
one's
her.
listening. Does he want
I'm going to say we did that. We have the power to influence Netflix.
to keep endlessly fighting because I want current support from her? I will never stop hearing about this 9 months. It doesn't matter who the judge is, whether there's lawyers or not lawyers, it's going to be endless. So are they willing to
Your Honor,
negotiate
that
something?
can't be the way that we try cases. It can't be the case that if a litigant has an unreasonable position, but they won't abandon.
Thanks,
That's not
mate.
what I'm indicating. In some sense,
I have a
the
reasonable
harsh
position.
reality of it, there
I'm
are
not
cases where you do have to factor in all those issues. And I had a few of those in practice, what my client will be enduring during the next few years, and even if you think judges have the ability to shut this down, do you know how many, some litigants file in a myriad of different places?
Well, let me put it
File in
this way.
federal,
If Ms.
they
Hurd
file
wants
here,
to
they
stay-
file there.
If Ms. Hurd-
This is not going to stop. He's dealing with this as a legal issue. This has
You're all being bogans.
manifestations more, there's behavior which is not gonna be curtailed by forcing things
Judge,
down people's
I
throats.
would
If we
say
can
this,
reach
if Ms.
agreements on
Hurd, to
something.
put this to bed, Ms.
Okay.
Hurd wants to tell the court what she, a statement, if you want to swear her in, let her tell you what her gross monthly income is. Okay? And therefore what the support order should be going forward. We will accept what she states on the record under oath as her gross monthly income, and you can set it there.
As long as the
And-
court takes into account the.
And then
arrears.
about the so-called arrears.
There's no order, Judge.
Apparently,
Then we
would
can
he
still look at
agree
it,
that
though.
her support order takes effect a year from now because of this? And I agree with you on this, this is really a reach, well, more than a reach. But if that's going to end this issue, would he agree that because of these purported arrears, well, I don't know what either of them were earned during that period, that if she says my support is 140 or whatever, it doesn't start
Your
for
Honor,
12 months?
It's well
That
settled.
way, no matter where this goes, who it's heard, that issue is dead
It's
forever
well
if they
settled.
stipulate on the record.
Okay, but I hear you, let me make sure I understand. It is well settled law that attempting, well, the judge,
Doesn't help. It's not gonna change my mind. This is, whoever doesn't understand the complex, if you keep quoting the law and think the hammer comes down, it's gonna end any of this, the worse it's perceived, the more he's going to suffer. I've seen these cases every 3 or
Well,
4
you
years.
put a
You
goat
see
order-
one like this, they don't
Judge,
end
you put a
unless
goat-
you get buy-in from
you
people.
put a goat order in place.
Okay.
That requires her to file with the court.
You know
prior to
how
filing a motion.
hard I've tried for those in like 4 or 5 cases?
So
and
are our
like
hillbillies.
vexatious litigant situations, and how difficult that is, and how it gets federally overturned. You know how difficult those
I don't believe you're
matters are.
denying her due process, and I appreciate.
I
appreciate
don't
what-
think it does either,
I
candidly.
appreciate what the court is saying, but I think that the alternative, Judge, unfortunately, is,
Okay.
it feels to me that we have waived arrears last time, we've expanded visitation, we've done all of the things to try to get to the place you're
Has he
talking
figured
about.
out what I figured out? She is going to
Yes.
commit her whole life to make sure he never collects a dime. Is he willing to keep fighting? There's no wage withholding.
All-
It's her own business she's operating.
All
What
I'm
is he
saying-
willing
all I'm
to
saying to
do?
Your Honor is.
What's he
let
willing
her
to
tell
do?
Your Honor what
Doesn't he
the
want
court
to
has-
end this?
I'm just, if I was convinced, Your Honor,
Well,
that if he
okay.
said that, then.
You may have a point. Okay, you're right. I should be turning my attentions to you on this. If they said you can say what it is you're gonna pay, and if we said on account of that, this purported arrears issue for 9 months, you don't have to start paying that amount for, I don't know, a year, would that end this issue? Well,
Your Honor,
would it, no, direct answer, then you can explain.
it's not gonna end.
Okay, it's not gonna end it.
Because there's also, if if I could speak without being interrupted.
No, you can't, because you must stay on point. I'm trying to help you. I don't help you if you throw 8 or 9 other things at me, or you distract me,
You're
or go
allowed
on
to
to other
speak.
issues.
Mr. Friedman,
Would
you're
that
allowed
end
to
up,
speak.
would
I'm
that
the
end
only
this issue?
litigant and
Do you
I'm
want
allowed
to
to
keep
speak.
fighting, or do you want to end it? Okay.
I want my daughter to
What
be
would,
safe.
no, we're not talking about that yet.
This isn't a child support hearing.
We're
This
doing
is
it
about
one at a time.
5-point harness car
Okay.
seat and a motion to set aside.
Okay,
This isn't even child
are we
support.
going to do this one at a time? You keep bringing up these issues. They're
I
all,
don't, you did, I haven't
young lady, there's
spoken.
only one way, if you have 8 important issues, let's say you've 8, let's say you've 6, let you have 10.
I have one, the
Okay.
custody of my child.
Okay, however many issues we have, we do them one at a time. Child support apparently is an issue, apparently more to them than you, I admit that. So, they either back off on this and say we're not seeking it, or we settle this issue. We're not gonna jump all over the place. And if it's all about,
What? What do you mean you put your headphones on at the wrong time? Don't take your headphones off.
your daughter, then everything else we don't have to deal with.
I
So,
don't care about
you
the
guys
money.
are hollering at me, it's an issue, then when I say, let's solve the issue,
Okay.
all I get is no. I gotta climb up on my
My
soapbox,
child
act like
support
it's
should
no.
be $140 a month. I would agree
Okay,
to that.
okay,
and we
okay,
can- we
okay,
can address
thank you,
arrears
thank you,
later.
thank you.
Let's do that.
Okay, so you're saying it should be 140?
Yes, and we can address arrears later.
No.
I don't care about
No,
money. They
if we,
want
if
140
we
a month.
come to an agreement, we deal with it all now. I don't want hanger issues.
There's arrears.
If you
so
agree to 140,
he owes me $7,000. So how do we
where does the
balance that out?
7,000 come from?
The we had joint custody. Which I
Okay,
never received
how do
child
we get
support from
7,000 if I
March
asked you for
2021?
those 9 months, what was your income and what was his income?
Okay, so if you want me to, this,
Just give it to, well, you know
I
it.
don't know it off the top of my head. His
Then how do you
income
know
is
he owes, how do you know it would
$75,000.
be 7,000?
Okay, he owes $75,000 a year. I didn't make anything
What?
because I lived on my
He
daughter's
he
SSI.
owes or he earned?
He earned.
He
I-
earned, okay, that's different than he owes.
$75,000 a year.
Okay,
My income was merely
Okay.
my daughter's SSI.
he earned
He cannot earn
75,000 a year. And what was yours?
nothing.
They had joint legal custody. She got all the SSI. He had the child half the time. And he owes her child support?
Because it was my daughter's SSI. SSI is not income. That is a state law, that is NAC, that is social security law. I could go in, I don't have them in front of me,
Actually,
but I can give them to you.
Leave it to the-
Actually,
Social
what-
SSI, when
it's
it
not-
comes to disability,
it can't be attached, it can't be it can't be divided as marital
it
property,
can't be
but
considered as
when we're
income.
dealing, and it can't be taxed, but anything is,
Well,
for
That's
child
my
support
only
purposes,
income for
anything,
that
but put
7
it
months,
aside, put it
March,
aside,
April,
okay.
May,
thing is
June,
fantasy,
July,
and the
August,
court would have
September,
also
October.
imputed
Pardon?
it.
10 months, that was my only income, was her SSI of, I think it was.
I like how you
That would
think.
impute some income, Judge, because she would have been unemployed,
I know.
which is why this is a
I
giant
can't, you
mess, and
can't
there was
impute
no.
income when I'm taking care of a child with a special needs. That's a different
You
kind
just
of.
stated,
it's not-
Ms. Hurd,
I'm not
you
taking
had
care of a
joint
child with a
physical
typical,
custody,
this is not a typical child.
but you didn't
This
have
is
an
a
order.
child with a special need.
Okay,
I'm intimately
She has
aware.
13
of that.
providers.
so what were you saying he should have paid during that 9 months?
But the child, I have the
We know what
letters.
you
Ask
meant
if you have a
daughters.
letter. How much
We
do you-
know. We're
You-
good.
You keep fighting everything, which means
I'm not fighting
you
it. I
present
don't
you're the
care about
most
the money.
prepared
They're
person on the
fighting it.
planet, and you're creating a record where I design questions directly about all of your issues, directed to help you solve them, and you don't seem to want to answer.
So you
How
just-
much do you believe the support should have been during that 9 months?
Approximately, during that 10 months,
Mhm.
total was about 7,000. Those are all
Okay.
approximate numbers. I provided them in the letters to
Okay.
Mr. Friedman, like 4 different times in the last several years. I don't
Okay,
have
I
that
s-
right in
okay,
front of me,
okay.
but that is approximate.
Okay, I suppose that
Just do it anyway.
if there's a big what if here, though. I suppose that if he was earning 75 grand converted to 57,000 during those 9 months, that if we divided that by 9, took it by 16%, we could get in that neighborhood, but there's a big piece missing. And that is that it assumes that mom should be assessed no income for that period, but, okay.
And also, the clear facts are that there was no.
So let me be a little more direct. If this custody's current child support / arrears issue ended today, what should the ruling or agreement be? Let's put it that way.
With just specifically child support, or are we talking about more?
Both, the arrears, the current child, the future, if it were to all end today, all of the child support, what should the order be?
Your Honor, I don't,
It,
if I.
no, I want you to, you seem to want to, okay, I can't help you, okay.
He should not have
No,
primary custody. He should have our custody arrangement
no,
should be different.
here's the problem. You cannot explain what you want until you
I
tell
can,
me
but it
what you
resolves
want.
around
Okay,
custody.
if,
I can't answer that without resolving custody. That's where you're telling, you're
All right.
asking me a question
All
that
right.
is
Okay.
the basis of
Okay.
custody. I can't
Okay.
give you a financial
Okay.
number when it resolves around custody.
okay.
And right now, there is no law,
Okay,
there's no record that
okay,
supports it
okay,
having primary.
okay, thank you, okay, so, putting aside the child support issue,
If you
Are
want
there
my money,
other
take all
issues-
my money.
are there
I don't
other
care about
issues that-
money.
are
I
there
care about
other-
my daughter's
okay.
safety.
okay. First of all, I do not tolerate people who file floods of paper, argue endlessly about these other issues such as support, and then when I try to help
Lie. That is a lie, Judge. Not only do you tolerate it, you encourage it.
resolve it, you get up on your soapbox, oh, it's all about safety, it has nothing to do with those other things. Okay, fine, it's coarse and awful to be dealing with the financial issues now. Now we've had a dramatic change of course. So let's put that aside. Aside from the custody, the generic custody issue, what immediate safety issues are in place that have led to your, oh, no, let's do this. What's wrong with the holiday schedule that was agreed to?
Well, first of all, I missed visitations. Because of your holiday schedule, I missed visitations.
My holiday schedule, no, young lady, the
Department
holiday
requires
schedule
holiday
that two of you
schedules.
agreed to, that you initiated, what's wrong with it? What needs
I
to be
missed
changed?
visitations. I have a limited
Wait a
visitation
minute, okay.
schedule. When I miss visitations and Mr.
Okay,
Prepares
wait a
now
minute,
got
wait a minute.
willing
You're
to-
not helping me to change, to give you what you want.
You're
When I
asking
say,
me-
how does the holiday schedule need to be changed? I missed visitations could be part of the explanation, but you first have
Make
to
that-
tell me, what do you want changed?
Okay, going forward, Thanksgiving, this will be the fourth year in
Okay.
a row that he gets Thanksgiving. I haven't had it for 4
Okay,
years. I will
well,
miss a
okay.
visitation.
Now, okay,
Christmas, I
thank
will
you.
miss two
When the
visitations.
order was entered that they stipulated to at that hearing, what was
It was-
it included a holiday plan, correct?
Yes.
How are we to know that far in advance? I didn't have a calendar in front of me. I
Was
didn't
it?
sit there to figure it
Did
out.
it include it?
Went line by line through
Okay.
the holiday schedule.
Okay.
And so I,
Not day by day.
Was she denied anything that was in there?
no, and in fact, my client gave her his Halloween this year.
Okay.
So I'm at a loss, Judge, and this is why
I'm
we
not
have
gonna
orders.
have Thanksgiving
This
for
is
4 years in
why
a row.
we-
I won't
Okay.
see her for 12 days.
Okay.
For Christmas, I won't see her for 16 days.
She
Mr.
had-
Overperry
Okay.
does not allow a
She
single
had
closed
That's
door
true.
conversation
Do you
with my daughter.
understand?
He's
that-
concealing my
do you
daughter.
understand that a court can take no action unless you tell the court, here's what the order is and here's what I want changed? First of all,
That's what I'm
what,
trying to do, Your
thank
Honor.
you, first of all, are you attempting to add something new, or are you attempting to change something that's in the holiday schedule?
The way the holiday schedule reads right now doesn't take into
Okay,
consideration that I
does
have,
the- okay.
that are,
So does that
it
mean,
takes away my visitations.
okay,
I don't
okay,
get
wait a
paid
minute,
time for
okay.
that visitation.
Okay, it was,
Every holiday
are
schedule.
you referring to things unaddressed in the holiday plan, or they're addressed but they need to be changed because they're unfair?
Both.
Which is it?
Both.
Okay. Which specifically in the plan shouldn't have been agreed to and needs to be changed?
Thanksgiving and Christmas.
What about,
because
okay, what about Thanksgiving?
Thanksgiving, this will be the 4th year in a row that he gets it.
Okay,
I
now,
haven't had it for
I have
4
to
years.
return to my question. I have to assume the plan does not say he gets every Thanksgiving, or does it?
No, it alternates.
But he has had her for 4 years
Okay.
in a row. This year will be
She's
4 years
talking
in a
about a
row.
period of
Okay.
time when she had no
Okay,
custody.
okay, hold on. This holiday plan was created before this Thanksgiving and after the last one.
Yes, and
So,
how was I supposed to know
okay.
predetermine what
okay,
visitations
how-
like weekends would
Thanksgiving
fall on?
is rotated, right?
Judge, I think I can clarify because.
We're not gonna be able to
We're-
change
we're-
everything that happened in their
we're
lives
not.
over the last several
There's
years.
no authority to change any of it unless you
I
wanna
will miss
modify it
3
after the fact,
visitations.
right? It was an order. But at bottom, I think
Is she
what she's
receiving this
telling you-
Thanksgiving?
I
No,
think what she's telling you, Judge, is, as we all know, holiday visitation trumps regular timeshare. And I
Right.
think what Ms. Hurd is trying to say, and tell me if I'm incorrect, Ms. Hurd, is that she takes issue with the fact that sometimes there's a holiday that belongs to my client that falls over what might otherwise be her regular timeshare. The same thing occurs for my client. That is a standard schedule. I think what she's telling you is, based upon that, she feels that that is causing her to lose regular timeshare, which is accurate, but it's true for both of the parties, because a holiday visitation schedule is always going to take precedence over regular timeshare. With respect to, when she's referencing Thanksgiving, okay, we were in the middle of proceedings, as I recall, last Thanksgiving, she did get the Friday immediately following it.
I got 8
This
hours.
Thanksgiving, well, that's what you're, but Ms. Hurd, you say you're missing visitation periods, but there were orders of the court
Mr.
limiting
Freeman,
and
you filed
restricting.
a
There's
notice
Dad.
of TPO in 2022. I wasn't allowed to talk to my daughter, know where my daughter was
Ms. Hurd.
for Thanksgiving,
Ms.
my
Hurd.
birthday, Christmas, and New Year's.
Ms.
You
Hurd.
filed a fraudulent TPO,
Ms. Hurd,
and this court has yet to address that.
okay.
Because, yes, because you came to a global resolution and now you guys wanna blow it all over.
No,
We don't
because I
want to blow
was
anything
forced
up.
into that global resolution.
You told me to leave the room so you guys could talk. And I
And
was-
we reached a deal, and everybody was on the record under oath, and we stipulated to it effective that day.
Because this court had told
Is
me
the,
over and over
okay,
again
first
I
of
could
all,
never even get
first of
joint
all, I
custody.
can't and won't, we could spend the next 2 years.
There's Mom.
looking back through
I have-
everything that happened holidays the last 3 or
I
4
have
years.
a solution.
All I care about is whatever, they don't have to use the plan from this department, they can use whatever plan they want as long as it's 50/50.
It was ordered, and it is 50/50. It is a standard holiday schedule, Judge. That's
That
what
I
it is.
missed most of my visitations. I was not see my
Okay.
daughter for
She's-
12
Have
days.
you been, after you agreed to this holiday plan, have you been denied your visitations
Yes, I
since then?
have. I've been denied Labor Day weekend. My visitations
Okay.
were denied.
Let me
Without
make,
admission
okay,
date,
let
my
me, I will rule
visitation
the only,
understand what she's
there's
saying.
only one way I am permitted to rule on this issue, which is as follows. Since this plan was negotiated by the parties without the court's involvement, and they asked that it become the order, I cannot do anything about what may have happened before the plan, but since the plan, if she's
No way, I'm enjoying myself.
been afforded all her time, I can't do anything. If she has not been, and she was denied Labor Day and some other things,
Understand what
she
she's
could be
saying.
compensated.
She's not
So-
telling the court that it was her holiday weekend and my client denied it. What she's trying to tell the court is, because it was his holiday weekend, right, it took over her regular timeshare.
Well, that's always the case.
But that's what she's telling you, Judge. That's what I think you need to understand. She's not telling the court,
For
he's
4
That's what we're
years
trying
in
to
a
find out.
row. I
Okay,
should
I'm
be
not dealing with
denied
4 years in a
holiday
row.
with my daughter for 4
I'm
years in a
not
row.
dealing with 4 years in a row, I can't, you guys came to an agreement.
there is a 50/50
If-
holiday.
okay, no, I
was
can't-
forced
no.
into that agreement, so I would like this court
You
to
were
enter.
forced to it, you
Yes, of course.
you offered,
So
you,
either deny-
you offered it. You said, I want
My
to
motion
negotiate
to
with
set
Mr.
aside
Freeman.
that stipulation, either deny it or approve it, so I can
You've
go
got a
forward.
point.
That's the only
You may
decision
be,
here.
you may be on target with that.
I think
Yeah,
you're right,
deny it
Judge.
or
But
approve
the
it. So now go
problem,
forward.
the sad problem is
We can go to Supreme Court. I can
you,
deal
that's
with that.
fine, you can
Ms. Hurd
spend
has-
your life there and that's fine, but the problem is, you seem to misunderstand something. You seem to think that if we change who the players are in this case, that you don't have to alter any approach and you can continue to fight endlessly, and that there's,
I don't believe
the
that.
rules are the same, well, never mind, okay.
Your
It-
Honor,
it's-
the
wait.
last hearing you said for Miss Carrie to stay away from me. She's been at every Monday therapy.
Okay.
She takes my daughter, this is a continuous
Okay.
issue, she follows me home
Okay,
from therapy.
let me ask you a
I want
question.
in order
Okay,
for her
let me
to
ask
stay
you a
1,000
question, let me
feet
ask
away
you a
from me.
question.
She's not the
Okay,
mother, I
if-
am the mother.
Okay, if I ask you specifics of what I need on that issue to help you get the orders you want,
Fozzie, are your
are you gonna
headphones on?
answer, or are you gonna say, why are we talking about this? It's about my daughter's safety. Why are we talking about these
Because
other
our
things?
safety is.
Do you want to talk, do you
Yes.
want to talk about this issue?
Yes,
Okay. Are you aware the order is she is not to be at the exchanges?
yes.
Okay, so what has occurred since that order was issued?
So she's at every single Monday therapy,
Okay,
which we're in close proximity. She's at every dentist appointment. She's at every physician's appointment. My daughter has
Okay.
a mother. Her mother
okay.
is entitled to
Do we
take her.
understand that,
Why
we're-
is
okay,
Carrie
okay, do
a
we
third party?
understand we're talking about, I can help you on that, as long as you
Okay.
understand, this is a separate issue. The issue of exchanges, she is to not be there. I don't think there's a prohibition against those type of issues. If you think there should be, that's fine, but there is, I don't think there's an
There
order
is
out
absolutely
there.
not, Judge.
You
What
said
she's
for her to
referring
stay
to-
1,000
fr-
feet
from
away,
the
and she
exchanges.
refused to
From
do
the
that.
exchanges.
Is appointments on Mr.
Okay,
O'Carty's
that's right, you
custodial
see.
days that she
But
chooses
he's
to
never
attend.
there.
Okay,
That she
Right.
chooses to attend.
okay,
He's
And then
allowed
saying
to.
that,
I choose, I'm her mother.
thank you, okay.
I get to attend
which is-
over a
which
third
is-
party.
Which is
Okay.
fine with us, Judge.
This court
But-
needs to make
Okay,
findings
how
for
about,
a
okay,
third
how about
party.
this, how about this? if it's during his time, but mom intends to participate, she provides him notice that she's gonna, 24 or some hour notice, that she's going to be there.
I'm there every time.
And then if she's there, for times that she's gonna be there during appointments that fall on dad's time, if he's on notice she'll be here there, he'll do the transporting to those appointments.
Well, the issue, Judge, respectfully, is
I'm not going that far. This man chose her. This man chose her. I do. Fozzie took his headphones off again. He's not even listening. Contempt. Contempt for Fozzie. Contempt. I don't know. We want to hear Carrie talk.
is that
He
these,
can't.
these parties are married, and my client does work, and so sometimes
He
his
can't
spouse.
do the
Okay,
Which
then
is
the
very
next
fine.
question
I can do the
is,
transport.
she
Let
would,
me
okay, the next
transport her.
question is, she would be ecstatic, apparently,
Yes.
on her time to load up each day with as many medical or school
Yes.
appointments. She will free him from this obligation.
Yes, I will.
I don't know that it's possible from a scheduling
Maybe,
perspective.
maybe
to
not,
put
but
time
could,
share for
could that be the
people.
goal? Put,
Yeah,
load her up with as much
yeah.
of that time as is
I have
possible?
rights over a third party, absolutely.
Yeah, so Judge, I don't know that practically the number of appointments.
Legally,
Here's-
it doesn't
here's-
matter about practically.
here's the
Legally,
problem.
I have rights over
Here's
a
the
third
problem.
party.
Despite any sort of behavioral concerns, if it's a special needs child, I can't tell a parent, you can't be at that
I'm not
appointment because
telling
it's
her.
on the other parent's time,
I'm not telling
which
her-
means she has the right to be there. And
Absolutely.
if she doesn't inform him, that's different, but if she says, yes, I will be there for
I'm
that
there every appointment.
appointment, then he should make alternate arrangements. Apparently, the police was summoned. We don't want these two involved in each other,
Please,
do
that's
we?
what I'm asking. I'm
So,
begging this court to
okay.
have Carrie
How
not
does this
ground me,
benefit
please.
Aslan, Judge?
Pardon? What? I'm
How
sorry.
does this benefit the minor child?
Because she has her mother,
Well,
not a
I
third party.
can't answer that directly, except anything that generally reduces conflict could hopefully have a spill
And let
down
me tell you,
effect. I don't know.
yesterday at her therapy appointments were so lovely not having Carrie there. There were no stress, there was no
Okay.
running up and down the stairs, there was no
Okay.
secret lobbies that I had to be in.
See, this is what I said earlier, but no one wants to accept it, because the two, mom and stepmom are in serious conflict.
Cause I have rights
And
and she
may,
doesn't.
you know, even if you're right about these things, even if, let's just assume all conflict was caused by them and not you, let's just accept that premise. That doesn't mean that overnight, that either parent, because we don't like how they interact with us or how their spouse interacts with us, that suddenly renders them a bad parent that's unable to meet the needs that they've been needing for years, does it? Does that make
Said that.
him a lesser parent, or you
Does
a
it
lesser
make me a
parent?
lesser parent?
No, of course not.
Then why do I get to not be at my
Because-
child's Mr.
because-
Perry has
because-
stated, I
because-
can't even go to my daughter's
Because
games
you
if
won't
they're
get out
there.
of your own
He'll
way,
remove
because you
her.
won't get out of your own way when I try and help you accomplish what you want. Okay,
you
if
want-
she informs him that she's gonna be at the, we have to have some sort of notification requirement. And if she wants to load up all of her time with these appointments, to the extent it's practical, can we aspirationally try and make, if
So,
not totally practical,
now, all of
can
the
we try and
therapies-
make 85% of it occur?
I mean, right now the therapies are Monday 3:40 to 5:40. So if we were
Someone
gonna
will get
try-
arrested
If we were gonna
otherwise.
try to, if we were going to try to change that to her, cause, you know. Well, you're certainly, I think what the judge is saying is there would be no prohibition on you going.
It might help if she told us what main appointments you're emphasizing, which tutoring, medical appointments,
100%.
educational.
All
what main-
appointments.
So the main thing is, I'm
What are
saying,
the
like
main
I said
ones?
last appointment, I wanna take her to school, I wanna pick her up from school, I wanna take her to her 3 therapy
Okay.
appointments on every single every Monday, she has 3 appointments.
3 on Monday.
I'm her mother, I have a work,
Okay.
the reason why I work for Uber,
When you,
I have a
when you
degree in psychology,
negotiated
Your Honor.
this,
I
did you
would do this
negotiate?
so I could focus on my daughter.
When you negotiated this timeshare, why didn't you emphasize the day that she has 3 appointments and ask
I
that that
tried,
be your
I
day?
don't get a response
Okay.
from them.
No, I mean, when you did negotiate this, did you emphasize that Monday should be yours for these reasons? Right? That's what
You said I would.
I didn't say anything, I said I
Yes,
will
you did. You
accept
said-
anything you
said I
guys
couldn't even
agree
win
to.
joint
No,
custody.
I said whatever you guys submit to me that you agree to, I will accept. So my question to you,
That's not true.
why, it is true, I would have accepted anything the two of you agreed to, but that aside,
He
Why
won't
didn't you,
agree
why
to
didn't you,
anything. He doesn't want me
well,
to
let me
be a
ask,
mother.
no, I wanna know, I'm not, this isn't meant argumentative, I'm curious as from a problem-solving perspective. Maybe these appointments changed, maybe they weren't
No, they
all on
don't.
Monday.
They're every
But
Monday
if
for
they
the
were
last
all
4
on
years.
Monday,
That's right, Michael. I need to set an appointment with you. I hope you're not very expensive.
why didn't you put a big emphasis when you negotiated
Because I was
that,
trying.
that Monday
I
should
was
be
trying.
yours?
I thought we could come to terms. I thought we could
All
move
right.
forward, and
Well,
that's
you-
not the
but you
case.
did
It's
come
gotten
to-
worse. Within 2 weeks of that, I was assaulted by his
I
wife.
didn't, that's not what I asked you. For the purpose of this question, you could assume the world ended after you came to this agreement.
I'm an
I don't-
optimistic.
Okay,
I was
when you
hoping we
came
could
to
move
this
forward.
agreement, why didn't you emphasize that you needed Mondays if we had all these appointments?
Because
for
they would not have agreed to it, and I wanted
How do you
to
know?
Hey, part-timer. How are ya? Part-timer? Fozzie's taking the easy way out. He posts and comment every 20 minutes. And then he thinks we don't know. He's not even here.
Did he
Because
say?
I asked them, and they would not
Okay.
even allow me an overnight with her.
Okay, what, did you ask them about Mondays?
Yes,
Did you tell them?
Yes.
I need Mondays because of all these appointments?
Yes.
Why did you make me ask you 7 times?
I have it in every letter
Okay.
that I filed to you for
Why
the
did you
last
make
year and a
me
half.
ask you
It's in
7
every
times?
exhibit that
Why
I've ever
do
filed
I
to
have to
you.
work so hard?
Because I have to
So
work
your,
so
I think your
hard.
answer is you did,
Yes,
you did, okay,
my answer is
okay.
yes.
And his answer when you said,
He doesn't give me an answer. He ignores me.
well, no, because you negotiated something. I'm talking about the day you negotiated something, not the parade of horrors, which may have occurred since then, agreed. The day you negotiated, why didn't you say?
They never married.
I have to have the Mondays because that's when the 3 appointments are.
Because I didn't realize that his wife was going to attack me.
Okay.
This was going to be a whole
I'm the one who
situation.
fakes
Okay.
it.
I was hoping that we could coexist.
Okay, okay,
We cannot coexist.
okay. So, so instead of me asking now 8 or 9 times, the answer should have been, at the time, I didn't think it was critical to request the Mondays because I thought we could cooperate with that, and we can't. But see how easy it is? Okay, so, aside from the 3 appointments on Monday, what else is there that's regular?
Take her to school. I'm
Pardon?
a mother.
To-
I want
okay.
to take her to school
To-
and pick her up from school.
To and from school and the
Yes.
3 tutorings on Monday.
Yes.
What else is
The
there?
3 therapies.
Pardon, 3 therapies all on Monday, right?
Mm-hmm. Yeah.
Okay. Are they spaced a few hours apart?
No, they're right back to back. All of
With,
them
at
are
the
not
same
hospital.
facility?
Yes.
Okay.
So she has speech and then
I have a
PT
solution,
and then
Jeff.
OT.
I have a solution. Currently, her schedule is Wednesday PM through Wednesday, essentially after school and everything, on week 1 through Friday at 3 o'clock. And then on week 2, she has Friday PM through Sunday at 8. My client has just intimated to me that if a party would like to pick the child up from school every Monday, Ms. Hurd, I apologize, sir. Ms. Hurd would like to pick the child up from school every Monday. She can pick the child up from school, take the child to the therapies, and then do the exchange at 6:30 PM on each Monday. And what we would do then, Judge, is on the week 2 schedule, we would just simply roll Friday, go Friday, Saturday, Sunday. Instead of being at 8 o'clock, it would go to 6 PM. Gives her every Monday, she can take the child, pick the child up from school, take the child to the therapies. She can be present for, all those therapies. If my client's able to make some of them, he will. And obviously, Miss Opari, Carrie, is one of the main caregivers for this child and absolutely has a vested interest in being involved in those and is
She has no
incredibly
rights
involved.
to my child.
Okay, Judge, I didn't talk the whole time. So, obviously, if your honor is inclined for the time, we don't see the basis for a prohibition, but if it simplifies matters for the court and gets us done, then this would solve the issue. She has Monday after school each week to take the child to the therapies, deliver the child at 6:30. The only change to the existing visitation schedule would be to add that Monday PM, let's say, 3.5 hour time, and then simply roll the week 2 schedule back from 8 to 6 PM.
Apparently, no one seems to be picking up and agreeing with, so I must be really wrong about this. I think that these are not independent, good faith issues which would exist if these people were getting along. I think 90% of this problem is that the mom and stepmom have some real real problems.
I-
But that said, she has the right, as the mother, she has the right to be at these,
Like I said,
and she
does that not
presumably
solve the
knows
issue?
more about the
Does
conditions.
that proposal not solve the issue?
It's more complicated than that.
Okay, oh, what if we uncomplicate it until such time as some other judge, which I think I
Okay.
am gonna make another attempt, here's
Okay.
all of your set-asides
Judge, I need you to.
and
I need you
everything.
to
Well,
rule-
I'll rule on it from my
I need you to rule on
perspective.
the set-aside.
If
I'm
she,
open to
Judge,
this.
if
not
she
me.
decides that, if she can convince the other judge that it was improper for the judge before he recused to rule on it, that's fine. But at least until such time,
Okay.
on the, there, you heard the schedule they're offering.
So,
and it sounds like it would obviate this
Your
problem.
Honor, so are you saying that in the interim of waiting for, this next judge to decide if we're gonna get a recusal, on a temporary order basis, that we would do what Mr. Friedman says? On a temporary order basis, I would agree to that.
Okay,
As a
with the
temporary order.
understanding
Final
that
order.
the new judge can do whatever they want, but I'm
Temporary.
indicating, and I don't think it's proper to issue a judgment if I'm recusing, but the court, I does not believe that there is a basis to scuttle this agreement, which was negotiated between the parties based on conflict between the mom and stepmom, which can be dealt with. But if the new judge feels differently, which they might, that's different, you know, but.
I would agree to a temporary order in what
So-
they
Judge.
stated.
Mhm.
Judge,
Yes,
I've put forth.
I
the
understand.
Each Monday, 3:40 to 6:30 PM, and the change to the week 2 schedule, rolling back Sunday from 8 PM to 6 PM.
okay,
The issue that I have, Your Honor may try to recuse yourself again, and I appreciate, you know.
I
this
think
court's
you
coming
can
from.
understand.
I can, certainly, Judge. But I happen to know that you're not going to get a new judge who's going to stand as an appellate judge for you. I happen to know that uniformly. They're not going to say, I'm going to consider a set-aside, right? So I need you to rule on that issue.
If
Obviously,
I rule on that, I'm gonna deny the set-aside, but then I'm not gonna deal with anything else because
well,
even if it's stipulated to, unless it's stipulated to, I'm not gonna make proactive orders if the courts.
I mean.
Because
you-
I've
you
already
just-
made it clear, I think these problems can be solved separately. They do not justify in any way, shape, or form, legally or factually, this court scuttling a stipulation that the parties negotiated. I've never set aside a judgment in instances like that because I'm not permitted. Unless there was a situation where it was subsequently disclosed that there was a serious mental defect that kept the party from reaching an agreement that I didn't know about at the time. But I cannot set aside an agreement.
There won't be a new judge. The chief judge already denied his request to recuse. He's not gonna change his mind. There's no reason. There's no lawful reason to recuse this judge.
Based on horrific things that occurred after it. That may be a modification. If she has the basis to modify or
Sure.
change it based on what occurred afterwards.
Sure.
But you guys don't, I want you guys to understand, I don't have the authority not to accept the agreement and not to disturb it unless it was something akin to lack of capacity, like a formation type issue that I didn't know about. It'd be hard to imagine how something like that could be concealed. The worst things in the world could happen after that agreement. It wouldn't scuttle the agreement by law. It could be a basis to dramatically change it for all I know. I don't know. But it can't, what Ms. Hurd doesn't understand is no matter how bad something is after an agreement, it can't disturb the agreement. The only thing that could disturb that agreement would be something like gun to the head duress or a mental incapacity I was unaware of, lack of ability to contract, those things. Otherwise, the agreement is the agreement. It's not disturbed.
So
But
He should order her to get a psychological evaluation.
if she has the basis to, I can't set aside that agreement based on things which happened since then. The law is abundantly clear on that. It's impossible. I lack that authority. Even if I want, no matter how much a court may want to, it can't. What it can do, if she's collected enough information to justify a modification, circumstances changing dramatically since then. What I'm hearing, I think what we need to accomplish here is that 80% of this or more is the relationship between mom and stepmom If that doesn't improve, none of this legal stuff is ever going to end.
Judge.
It's a behavioral issue with a legal backdrop, it's not a legal case per se at this point, nothing's gonna change.
Preaching to the-
You have to cut out the cancer, which is this relationship between the two of them. It's going from bad to worse. It's manifesting itself in endless proceedings because people know enough not to take the law into their own hand or to get sucked into too much confrontation. So she's handling it through the legal process. But
So,
I'd agree with that.
what can you do? What can you do to? Now, maybe the way to improve that relationship for now is to keep them as far away from each other as humanly
Please.
possible.
Thank you.
But beyond that, if I was in a position, in speaking from some degree of experience, some significant degree of experience, if I had a special need troubled child, I learned real early on I can't indulge. I don't have to indulge any of my own anger. I have an obligation to make my worst enemy in the world my best friend, at least to addressing this child's needs. It's critical. You cannot afford this degree of conflict with a child with this degree of special needs. No, any sort of special needs, any autism anywhere on the spectrum, you cannot, good parents cannot afford to indulge this. They cannot.
so Judge.
And no parent ever puts any stop to this. If we start from the therapeutic perspective, everything's 100% your fault and none of it's mine. And as if they're both polarized that way, we're never gonna get anywhere.
So Judge,
you know.
I think that I would ask the court to make findings today that the motion.
So in
is
other
set
words, this
aside.
isn't worthy of
No, it is,
exploration,
Judge.
that if we deal with this issue between the two of them, we can maybe either de-escalate a lot of this or even put a stop to it. It's just-
Judge, I respectfully am happy to engage on those issues.
There are special
Because-
needs children who die because parents remain in conflict, then it becomes a power play. I'm not gonna administer this medication or pursue this treatment because she told me I had to do it, or why should I listen to her? Things can and will actually get a lot, it's got to stop, it's got to.
Agreed. So Judge,
I
the
think
order
you're
is the
answering
order.
that.
I would ask that, based on what Your Honor said, that I can prepare an order with sufficient findings stating the court is denying the motion to set aside.
To set aside, not as to anything she filed that
I'm saying.
is a modification or a
Right, that's
substitute.
fine, she can do
Okay.
that. The reason I'm
She
saying
already
that
did,
is
there's a
because
million of them,
my sense is, Judge, and you heard it, is that Ms. Hurd is going to appeal regardless. The decree, the ship is sailing
First, I
on
think
appeal.
she'll see with the new judge what she can modify
Well,
probably.
Okay.
And then, if, depending on that, yes, you know,
I suspect that those efforts, well.
well, I don't know.
I am right
have-
here, you
I
can
have
ask
some-
me.
I have some sense of how that goes,
But you can't call him a liar. I want you to communicate effectively, but you can't call each other names. If you wanna
I-
communicate constructively, then that's fine.
I'm trying, I
Can't call each
constantly
other
get
names.
interrupted. I would love to have a conversation.
I'd be more than happy to excuse myself so you can do just that.
Judge, I can prepare an order, that motion to set aside
I
is
thought the
denied
person who
with,
does the motions is the one who prepares the orders.
That's fine.
no,
I could
Judge,
prepare the order.
Judge, you're gonna end up with competing orders in this.
I
It needs
know.
to have the requisite findings and citations to be able to be.
I don't mind as long as I get CC
I
and
will
I'm allowed to,
absolutely
and I'm
provide
allowed
you-
to look at it and make
When we-
modifications
can
and
we-
approve.
We're gonna do something
But it has,
specific.
the modifications have to be consistent to what was ordered.
Right,
Your Honor,
I
your
agree with
findings-
that.
your
Just
findings-
don't do it behind my back,
Your
please.
nothing
That's all I'm
is
asking.
fine.
Let me sign it, let's do this like by EDCR.
Your Honor, your findings are that the motion to set aside is denied, that you did not find a sufficient legal or factual basis given that the parties were present in court and canvassed under oath and stipulated to make the order
Yes,
effective
but
that
if
day.
there's, as to all, most of these motions concern subsequent events and are more in form of, although couched in terms of voiding that agreement, are more in terms of a modification based on subsequent events.
What I'm saying is
Right,
the
I
order will
understand,
not
yes.
address whatever Ms.
It can't.
Hurd believes she can, right, that's
It
a
can't,
different
that's
situation.
modification terrain.
Correct. So we will make that very clear. What I would like to do is have an order from this court that I will provide that to Ms. Hurd via email.
Okay,
I would like to put that email on the record, that I would like to have her have a period of 7 days for review and comment. And then if we do not get a response within 7 days, we will copy Ms. Hurd.
Do you need
on
more than
correspondence.
7 days?
No, I didn't.
Okay.
Okay, so I will
The
prepare.
court's gonna attempt again to recuse.
I appreciate that.
I will
Thank you.
But here's the problem. There's a few, and that's fine, those will be the orders, because I don't have the ability to void an order based on subsequent events. Sometimes those events could cause a different custodial order than you guys agreed to at that time, sometimes dramatically so. But it can't void an agreement that was agreed to at the time. You couldn't even do that if someone went out and killed 5 people. That wouldn't void the previous agreement, because the 5 people were alive at that time. What it would do is, obviously, full custody would be vested in the other party with no contact to the person now who's sentenced to prison. But we don't retroactively scuttle.
How does he tap out? The only way to tap out is to give the mother the child completely and pay her.
Orders that were meaningfully agreed to based on things that happened subsequently. And that's not to be twisted around into saying custody doesn't change if you kill 5 people. You know what the point I'm making. No
Precisely
matter
what
how
Your Honor is
horrific
referring to.
something is, if it's subsequent in time, the law has made it clear it's a modification.
Your Honor is obviously.
Unless something was concealed and those crimes were committed before the agreement,
Sure.
we didn't know. So if there's, like, if
Sure,
there's
I've reviewed her motion,
serious
that's not the allegation.
concealment about criminal activity, or basically what I came back to, the way to attack those type agreements is limited. It would have to be limited to capacity formation issues, basically.
I agree, and she was canvassed about that as well. So that would call into question a whole slew of other issues. But I heard the court.
So
I
the
think Your Honor's
court will
trying-
attempt to recuse again. From this court's perspective, it can't set aside the custodial order of insert the date which was negotiated at the behest of the parties. And there's a series of motions which, again, the court doesn't view, they're called set-asides, but they're more in terms of, look what occurred since we came to that agreement, look what his wife did, or look what he did, all which is subsequent, look what days I was deprived of, which, for all I know, could be it could be effective, I don't know, it's just that he can't do violence to an agreement which had existed before. The law just doesn't countenance that. Now, that said, probably all these motions, whether or not a reassignment from another court to another court is accepted, they probably need to all be combined. We don't need to be, okay, we're gonna come this week for holidays and it requires an costly opposition, and this next week for the seatbelt and all this, and the next week for who's gonna be at the therapy or any of that. She's agreed that until she gets a chance to argue her modifications to the agreement, which the court is not setting aside, she has agreed to a schedule which should, with that understanding, the court's not setting aside the agreement, she has full ability to modify it based on subsequent occurrences, and in the meantime, in everyone's best interest, it seems, without doing either violence to your right, to have the court rule, yes, that was a full canvassing, that it was a knowing and intelligent agreement, and in full fairness to her, but if things occurred subsequent to that that justify a custody modification, with full protection to both parties.
I love waffles.
It might help if the schedule you suggested, if it's agreed to, we can eliminate this issue about the appointments, let mom.
Here's what I will state, and I think it will satisfy Your Honor.
Okay.
What I will state, because I want the record to be very clear, that the order that was entered at the conclusion of the trial and that subsequently was reduced to writing and signed off on by this court will not be disturbed. You made
Yeah, I
that very
can't,
clear.
unless
You
I
made it very
had,
clear. Judge,
unless I had letters from her
Right.
therapist saying
which is
she's
not
unable
before
to
the court,
contract
which
or
is
something.
Not before the court
You
at all,
know.
that's not what she pled. So, that will remain. What we are willing to do, and this is why I wanted to make the record very clear, in no way conceding the merit of the defendant's perspective, in no way conceding that her claims about Carrie and about their interactions are accurate, but simply as a means to try to
I love
build a
spinach.
character and avoid, if possible, further litigation. My client will agree to the modification, and I understand, and it would be to the defendant's point, we'd be fine with, I think, would be fine permanent, but I understand she wants to pursue these modifications, so it will be a temporary
Judge frosted
modification
mini wheats.
for solely those purposes, without in any way an admission or acknowledgement of the veracity
With
of
either
the
side
claims.
preserving their
And it-
total rights.
And it will be,
I would agree to that, and I
it
would
will be
agree to the
Monday
intern child support in
It will
that
be
case.
Monday after school. She will be responsible for the child's appointments. She will return, and this will be each Monday, she will return the
Judge
child
Hurd.
at 6:30 p.m. And then
So
the
do I.
mediation to the regular
So do I.
timeshare will
Like
to
Popeye.
effectively add those 3.5 hours or 3 hours, whatever that is. And on the week 2 schedule, which is the Friday, Saturday, Sunday, the Sunday exchange will roll back from 8 p.m. to
Hi,
6.
Robert.
So the new exchange time will be 6 p.m.
Wait,
on Sunday.
she doesn't end therapy till 5:40
Okay, so what should,
5:40,
okay,
and we have you returning the child at 6:30.
does that work?
Oh, 6:30, yes,
Yes.
6:30.
6:30. Each Monday after school till 6:30
Yes.
with her doing all of the therapy appointments on those days. And then the change to the Friday, Saturday,
Popeye
Sunday
said so.
portion, rolling the time
Okay.
back from 8 to 6 p.m.
Sounds great. I do have to ask a question because and I'm not asking
Hi,
a question,
Jojo.
who has the right to do what as a mother or stepmother? I understand the arguments, I'm her mom, it's my right, I have that right. I think what's important, if we have a child with special needs, judicial officer would be remiss if they didn't say, is it about just pure rights or who controls what? Or is there something, and I may regret asking because I want things to stabilize. The last thing I want to do is invite something which could create more conflict, but I'm not doing my job if I don't ask. Is there something that stepmom needs to understand about treatment, medication, tutoring, that according to the experts you two are not on the same page with, that you need to get on the same page with? Or you're not necessarily anything? If you have something,
I do, but for purposes of where we're at right now, I would.
okay, fair enough,
I
good.
think you're, yeah,
A good choice, probably a good decision, but I just thought if there's something really important, we
It's-
could
it-
find out now. If not, it can wait. But and one of these motions is, which I assume if it goes to another judge, it's all gonna be combined. The holiday agreement. No judge hearing this thing in March is going to be able to fix what we don't like about what happened at Thanksgiving or Christmas.
I just don't
You
want to
could, you
sound
could
like
have,
expectations.
you could have your first cousin up there here on this, and they would not be able to do anything about holidays that already passed. So with the
Right.
understanding that if it's necessary, and I don't think it will be necessary if we clarify this, that she can temporarily still maintain her holiday motion on calendar. What is it that needs, is there something that needs to be agreed to? Now, we're not gonna solve this issue about he had the last 4 Thanksgivings if when they
I
agreed.
could at least not miss my
Okay, if they
visitations,
agree,
I'd
when
be
they
happy
agree
with
to a
that.
new schedule, could they agree, though, that for now it rotates until she convinces a judge to do something different, but that she'll get this Thanksgiving and she'll get even Thanksgivings and he'll get odds until we get this cleared up? She's getting odd or even, is she getting this year?
I don't get this year.
So can it be changed,
No,
at least
respect-
temporarily, to her
respectfully-
getting
respectfully, Judge,
even
no.
and him getting odd?
No, and I think that what you need to clarify, if
And
you're,
that will be 4 years in a row that I don't get her for Thanksgiving.
what you need to clarify, Judge, is when Ms. Hurd says she's
How is that
missing
in the
her
best interest of the
visitations.
child?
No, I get that point.
I
I
think she
understand
just
the
fundamentally
point.
misapprehends.
I understand the preemption may not have been absorbed. Holidays preempt regular time, so of course you'll lose time when he exercises holidays, but by converse, he'll lose time when you exercise your
Right,
holidays.
but
That's
I,
correct.
I have visitation, so I'm
Okay.
gonna miss 12 days, for Thanksgiving, I won't see her for 12 days. During Christmas, I won't see her for
No,
16 days.
I understand the
But
concept,
he
you
doesn't
know,
even allow
it
phone
is
calls. I
true.
won't even get to allow
It
a
is
phone call.
true, but the
He
court
denies
doesn't
all
really
phone
have an
calls,
avenue
Your
for it.
Honor.
It is true that someone getting their time preempted
Right,
is
but
more
when I've missed
precious
out
than
on
someone else,
almost
because
3 years.
they have less time than the other person.
Yeah, but I've
So it
already
does,
missed out
you
on
know.
almost 3 years,
So,
and he doesn't allow
okay.
phone calls.
So with
I
the,
had a phone call with her. He doesn't allow a single phone call.
When
Every
he-
day he
okay.
denies them.
not allowing phone calls, we will deal with in 15 or 20 seconds once we work through this. Okay. Now, I understand I think she understands the preemption issue. I think what she's arguing is that if the party who has less regular time is preempted, they're taking much more of a hit than the other
Correct.
party with the holiday preemption.
Correct.
That being understood,
But Judge,
with the understanding
Tuesdays or Wednesdays?
that this holiday plan remains mathematically identical till
That's
it's
correct.
argued, but for now, she gets Thanksgiving.
Judge, I don't think there's
even she gets holiday.
any basis in the
I didn't
rules
say
to
that.
do that.
I didn't say that. I didn't say I'm going to rule on this. I'm saying to eliminate a lot of stress and probably eliminating the holiday motion altogether perhaps. That seems to be a biggie for, well, okay, for Christmas, who's supposed, are they each
Do you
getting
wanna,
half
do
this
you wanna
year?
ask Ms. Hurd if
Are they each
if
getting
that
half
would-
this year?
they have, literally, the order is a 50-50
Right.
No, it's not, I
division of-
get 5 days, he gets 11. That's not 50-50.
It can't be.
That's how your order, that's how the
No.
holiday schedule goes. It
No,
goes from
no.
the day after, yes, I get 5 days,
Judge,
he
what
gets
she's
11.
referring to is the way that we peg Christmas break
Right.
in two segments. And so we peg it to be as reasonable as possible,
Right, if I get a whole week,
As-
I don't oppose that.
Judge. You
But I only
follow
get
what
5
I'm saying,
days.
Because Christmas is not always exactly in the
Okay.
middle of the winter break.
It's
And the
exactly 2
reality
weeks.
is it is as your honor knows, because you've been doing this a very long time, there is a natural ebb and flow to the way these go. So yes, you may have sometimes where Christmas falls, it falls earlier in the break. So the second half of the break might be longer.
And
And
suppose
then-
they each get half.
Well,
I don't
it
get
is
half, I
this-
get 5 days, he gets 11.
in one, I don't know that that's the case, but it may be.
It
the case-
is, I
may
laid
be
it
the
out.
case in one specific year because of when Christmas happens to fall, right? So
Okay,
if you
so if
have.
I get her for a whole
Well-
week, the day she gets out of
She
school
gets
to the following week, and then he gets
Okay,
her 1
would
week,
it
I'm
be-
okay with
Would
that.
it be fair to say that,
She gets the child.
would it be fair to say, and winter breaks are sometimes different than Christmas,
Winter
that's
breaks are
correct.
2 weeks.
Would it be
CCSD
fair
is
to, would it
2
be
weeks.
fair to say that most Christmas breaks are roughly
2 weeks.
December 22nd to January 2nd, 3rd,
Yeah,
surrounding?
well, February
Roughly?
6th. Yeah.
Well, what is it this year?
This year, it's from the 21st,
Okay,
December 21st to January 5th. I think they go back to school January 6th.
okay, so,
It's
okay.
exactly
Now, by
2
way-
weeks,
by way of
14
example,
days.
looks like 15 days, why
By
don't
way
they
of
both get
example,
7.5 days?
Great.
Judge, let me show you.
I agree.
Just by way of example, the very next year,
Super
Christmas
easy, I
falls,
agree.
Christmas falls on
Right.
Thursday, okay? So the
Falls
child's,
on Wednesday.
Christmas Eve is Wednesday, Christmas is Thursday, very next year. And that is my client's Christmas segment. So what he's going to get, that segment is
We're
Saturday,
not
Sunday,
talking about
Monday.
next year, we're talking about this
Okay,
year.
but Judge, what I'm trying to
it's
point out
all-
to
you
the
have
court
to
is
consider all of it,
that is
yeah.
how it works. This
Well, I
is,
haven't had her for 3 years.
this is, Ms. Hurd continuously seeks to bend this court and bend the law to
I'm not bending the
her
law. Not
specific
absolutely.
desires. But this is
That
about
policy is
equality and
equal
parity.
rights.
And it will be, if you look at the very next year, the exact situation occurs in the inverse. And
Okay,
you're saying, we're
but
not
you
talking about
denied
next year.
me even able to talk to my daughter on
He's
2022. You
Judge,
filed a frivolous
We're not at
TPO.
that issue yet.
Judge.
So 2 weeks, I agree, the 21st to the 28th, he gets the
Now, with
28th
the
to
understand-
Judge,
with the
I would
January
strongly
4th.
caution this court against
Super
wholesale
easy.
revising an order that
Okay,
is put in place.
not ruling on any of it. I'm just making some suggestions, which I think in theory you agree with the understanding that Christmas Day as the break point. And
That's
I
only
think
5
I
days.
understand
That's
what
only
you-
5 days of school.
Sometimes what's happening here, and I think you just explained it in detail, the reason we can't do a straight 50-50 each year, but it equalizes the next year when when the other side gets the bigger half, is the
Correct.
party that has Christmas Day and then they have to turn over to the other party. The party who has the 24th and 25th gets the much shorter period, about a third, not really half, but a third.
And that would be
The other
okay.
party gets the 2/3.
But I haven't had her for 3
Now,
years.
what we could do, so we could either do
Switch it.
that, where so it is true that one party could get like 2/3 1 year and the other gets 1/3, but then it reverses, as you say.
Right,
Now,
but I
what they
haven't
could
had
do
her
to
for
avoid
3
it, if they
years.
really wanted to, they could say the whole 14, 15-day break is simply cut in half and we alternate the halves. They could
That's
do
what I
that
would
if
agree
they
to,
want.
because she's gonna be babysat by a third party anyway, she's not even gonna be in the custody of Mr. Perry.
Okay, so, well,
My
you
daughter
have the right
deserves to be with
you
her
have the
parent.
right to leave it with your mom or whoever else you want.
Yeah, but I
So-
don't, because.
Yeah, but you have the right. And children love to be with their grandma. So,
Not every day.
well, you may have points, I don't. So, it's, as you explained it, which is true, the party who has the Christmas day usually has to turn over the next day, which means they only wind up with more like a third, not half, and the other side gets the 2/3. But then, as you point out, it's corrected the next year.
Right, if I
So
haven't
they
had it
wanna
for 3
continue
years,
that
let's
approach, or
switch
they
it.
wanna just cut the whole 2 weeks in half and alternate the halves? Those are their choices, right?
I would agree to cutting it at least in half, because I haven't had her
My
for
rec-
3 years for
Pardon?
Christmas.
My recollection, Judge, was that we specifically tailored the plan around an exchange the afternoon of the 25th.
Right.
Because Miss Hurd wanted to be sure that she had time with the child
That was last
Each.
year,
Christmas.
that was last year.
And so, if you are to do that, right, and I'd have to talk to my client, if you're talking about a stipulation, what's going to be is that there will be entire years where the child will not be with mom at all around the Christmas holiday. It will be, let's say, the 27th or the 28th would be the exchange.
Well, right, and
And that's why
the
it
way
was
you
crafted
explained
that
it
way.
is how we wind up with this 1/3, 2/3 thing, is we have an
Because of our
exchange
Christmas.
late on the 25th or 26th. But they could agree, take the whole vacation, cut it in half, alternate the half, so 1 year he gets the 24th and 5th, the next year she gets that, but in all years, they each get 1/2.
I would agree to that.
I have not gone through it
Okay.
to verify, Judge, but I want to make sure that here's the issue that I've seen occur. And I haven't run through the calendar to make sure, is that sometimes, based on when the district does its breaks, you can end up in a situation where you might not get all of Christmas in that first week. And so you might be in a
I'm only
situation where
talking
that
about
week
this year.
ends.
Let's just focus on this year.
But Judge, do you see what I'm saying? She only wants to talk about this year. So then what happens is we put that in place, and then in 2 years, you end up in a situation where
It's temporary.
it's her, let's say her Christmas, and now the exchange is supposed to take place on Christmas Eve, because Christmas Eve happens to fall on a Sunday, right? And what you're gonna hear from Ms. Hurd is, it's denying her Christmas holiday.
Right, but when I've had this issue in the past, since Christmas vacation usually starts 21st or 22nd,
It does.
and children are usually returned to school 3rd, 4th, and 5th, if we just take that whole
Sixth.
break and cut it in half, almost invariably, whoever gets the first half gets the 24th and 5th, always. And then if we rotate that the next year, then the other side would get the 24th and 5th. Does it make much difference, as you suggest, whether it's 50-50 each year, or 1 year someone gets 2/3, the other gets 1/3, and then it's equaled out the next year with the party with the short end then gets the 2/3? Probably
So Judge,
not,
by-
but if they
by
want
way-
to agree
by
to
way of
something
example,
different,
Your
that's
Honor,
fine.
in 2022,
Mhm.
Christmas Eve was Saturday, Christmas Day was Sunday. So the Christmas break started at the conclusion of the release from school on the 16th. The 17th, 18th, 19th, 20th, 21st, 22nd, 23rd, 24th would have been the first week. And Christmas Day would have gone the other way.
Right,
And
keep
so
all the
I
photos
going
in
back,
video, so I
literally
didn't get
just-
the
yeah, I
chance to
remember that
hear us
happening
talking
a
about
couple
that.
of years ago
And
on
just
several
going back
cases.
2
Oh,
years
22, yeah, I
to
remember
define a
that, 2
situation where,
cases that
and then
happened.
it's gonna be an issue because,
2022.
I remember that argument from a couple of years ago because of that dynamic.
right, so it occurs, and that's all.
Yeah.
I mean,
I would like to get some kind of
In
settlement.
a minute, you wanna
Thanksgiving and
talk to
Christmas.
them about this? I'll excuse myself and you can talk to them
I
about
would agree
Christmas
with
and
the cutting it in
Thanksgiving.
half, and at least Thanksgiving, me not being denied my visitation. My visitation's Wednesday through Friday, he could get the rest of the weekend. If I'm just not denied my regular visitation and split Christmas in half, I'll agree to that.
what about this? What if we just, because of the way that it floats and worrying about impropriety and the cutting off of the holiday, what if we just called it the morning of the 26th?
No, 1 week, 1 week, we each get 1 week.
It
It's
may
2
be,
weeks.
it may end up, the year I was just referring to would have been longer than a week.
This is just a temporary order, this is just for this year.
But would we agree generally, whoever gets week 1, then the next year, the other would get the week 1? Whoever gets the week
Right,
1
it
gets
alternates.
Christmas Eve and Christmas Day.
Well, I was saying the 26th as the cross point. So the first half of the break would go from when the child's released from school.
All I know is
so-
if you guys come to an agreement, at least you have to dump this
The
this
issue-
motion, this holiday motion, because there's a separate motion on that.
That's the question, is if we resolve
The
around.
21st through the 28th, and the 28th through the 4th, that's 1 week, 1 week, it's super even, it's cutting in half.
But does it, but is that a final order and we're not going to
He
court
gets 7
on?
days, I get 7 days,
If,
yes.
yeah, if you guys agree,
Mitigating
either
this
on
holiday.
maintaining it like it is, or splitting the halves.
And at least for Thanksgiving,
In
this is the
most
4th
cases,
year, I
in
don't wanna
most
miss my
cases,
visitation.
not all, in most cases, the parties just split the half and they each get a week
I
and
would
they
agree to
alternate
that, and
that
at least
week.
Thanksgiving, maintaining my regular visitation, I don't need additional, just maintain my regular visitation. I don't think that's asking too much.
I don't understand, Judge.
And then we can get to phone calls.
Okay, so the holiday schedules are holiday schedules. They take precedence over regular timeshare.
Right.
I
But when
didn't
one
create the
party's
law, that's the
denied
law.
time for
Right.
child,
But we're beyond that, I think it's a matter of, here's what it amounts to.
Beyond the law.
Should we have a Christmas which is one party gets 1/3 one year, the other gets 2/3, and then the next year it reverses? Or should we look philosophically at half and half? In either situation, whoever gets the first half, or the first third, if you look at it that way, is gonna get the 24th and 5th, so it doesn't seem to make a lot of difference one way or the other. Whoever gets the first half or the first third, if we're gonna do the 2/3, 1/3 rotation, or the half and half, is gonna get Christmas Eve and Christmas Day.
let him have let him, let's switch it this year. If he wants the 5 days and I'll do the 11, we'll switch it. Let's do that. If that's what he wants to do.
Now, we do have, fortunately, the only item that's technically on calendar beyond today that may change is on the 14th, emergency amended motion
That's
for
for
holiday
holiday.
schedule and request for restraining order. I'm hoping the agreement we've reached in concerning the therapy, that it's moved to mom's days and we change the schedule at least till further order, is gonna eliminate the need for a lot of this. But let's
Yes,
first
I
deal with
agree.
the holiday. Do we want to agree to that Christmas half and half?
I would
You're talking about a simple divide on the Saturday evening? Like, so, school recesses on
Right.
Friday, you're saying Saturday, Sunday, Monday, Tuesday.
Right,
Wednesday,
like if it's
Thursday,
out on the
Friday,
21st
regardless
this
of where it
year,
falls?
it looks like it's a 10-day,
It's out on the 20th.
it's 10
it
days
starts on the
this year, the
21st.
21st to the 5th, 10, 11 days, whatever it is, so
And
each
it
get
goes back to
5.
school
Judge,
January 6th.
Let me make sure I
Whoever
understand
gets
so that I
the
can talk
first
to my-
5 days gets Christmas Eve and Christmas Day and
Now-
returns on the
now, Judge,
26th.
So what you're saying then is, however, if it's a year like December of 2022.
I remember that being a problem.
What you're saying
in
is,
some cases.
now it would roll longer, or it would cut off
I
on the
did have
25th?
that dilemma a couple of years ago, and you confirmed it was in 22 on several cases. So I guess I wasn't necessarily addressing what if we have another 2022, but I guess we could. But just in general, it's usually 10 days, what if we just split it? Whoever gets the first half gets Christmas Eve and Christmas Day, then the next year it rotates.
I truly believe that the schedule that's in place is trying to do that, but
It looked
we
pretty
certainly
close.
can always,
It's 5 days and 11 days, and the fact that I haven't gotten to spend Christmas with her for the last 3 days, can we at least
Now,
switch it?
where do we get,
Judge.
by the way, where do we get 16?
I can't handle her saying the same things over and over again. Can she not hear what they're saying? Ma'am, shut up.
Days from if it looks like 10.
it gets
Where do we
worse.
get,
Look
where
at
do we
So,
get,
my
23,
last
Judge.
time to see
20
her,
where'd you
my
get the other
visita- I would
5
miss
days
2
from?
visitations. I would miss a
The
weekend
21st
visitation.
through the 5th.
Yeah,
It's
I would
10
miss
days,
a
not
weekend
16.
visitation and a midweek visitation. So
Well,
I
you
would
can't-
not
okay.
see her for 16 days.
Okay, but that's fair
But I'm
enough.
agreed
But,
to half and half.
okay, that's fair, but that's
They don't wanna
not,
do that.
that doesn't mean that the Christmas vacation is 16 days because you
I wouldn't
go,
get- no, I
you
didn't
go a
say
long
that.
time without seeing her due to the schedule. That doesn't mean we pyramid those other days on and indicate that
I never
he's
said
getting
that.
5 more days on Christmas than you do.
I never said that.
Okay, fair enough. So what do we wanna do with the
I would
Christmas
also point out-
vacation?
I don't
So
know why we
is-
just can't split it 7 and 7. That
because
seems
just so
super
Ms.
easy.
Hurd's clear, 2023, okay? School resumed,
Let's go to the
recessed on the
past. What does the
15th.
past have to do with
Because
this
it's a
year?
year ago, and it's demonstrative, okay? Saturday was the 23rd. So the first week would have given you the 16th, 17th, 18th, 19th, 20th, 21st, 22nd,
I don't understand
23rd.
what looking at past dates will help us with this year. I
Oh,
really don't.
that you should take that lesson in mind. We need to not be trudging through the past, but look at our future issues to solve.
That's what I'm trying
Because
to do.
Okay.
Judge, I'm just foreseeing a problem when you do it as a week and a week.
This is just in
Calendar-
the interim though.
Okay, but that, in the interim of what, though? You're always gonna divide the winter break, is always going to be divided as a holiday break.
Mhm.
So it's going to be something that is going to repeat itself, which is why
Okay, so
prototypically,
why not
I
do this
key
1 week as per CCSD calendar?
okay, but Ms. Hurd, you follow what I'm saying, right? The year
Do you follow what
immediately,
you're saying? And if you hadn't denied me my rights to even talk to my daughter in 2022, maybe I could trust you, but I don't. I'm not allowed to even have a phone call with my daughter. Last time I was allowed to have a phone call was
Judge,
on
I'm gonna ask
October
Your Honor to please put it
22nd.
in.
Okay, technically, the winter break starts the 20th, Friday, December 20th.
Yes.
and resumes Monday the 6th, January 6th. So we have, I don't know, maybe it's a little more than I thought. So,
No,
so
that's it, you're right.
it's, it looks like about 16 days. It does look like 16 days this year, not
Oh,
10.
look at that.
It's always gonna be 2 weeks with 2 weekends.
Mm-hmm, yeah, so at least 14, 16 days, yeah. Why don't you just divide it in half and rotate the halves and make life easy?
I would agree with that. Like I said, about 10.
It may not be
times.
too original, but what it lacks in originality, it makes up with, in fundamental fairness, everyone gets exactly the same.
Right, that's what I would agree to.
Now, you can discuss this, because I may take a break and leave you guys to finalize a holiday plan. She also seems interested in being Thanksgiving in even years rather than odd, so she can have Thanksgiving this year, because she hasn't had it in a few years. So,
Sure.
now, on this issue, since the motion that's for the 14th deals with the school issue, the holiday issue, which I think you'll resolve, this so-called restraining order issue is hopefully resolved by an agreement that, since this schedule is changed, and Mom will do all the heavy lifting on the Mondays for all these appointments, and the generic order that Mom and Stepmom are to stay away from each other. Now, have there been any further sporting events where they've both been at?
Mr. Perry doesn't allow me to attend, otherwise he will remove the child from the sporting events if I go, which is in violation of the stipulation.
I love that idea.
I'm sorry, I asked.
Good job, Dad.
Right. If,
Um,
if each of them just wants to do sporting or other events on their time and not have the other one there.
Stipulated.
But I only, no, because I only have her 2 days. That's not fair, that
What,
I don't get to go to any of my child's activities because somebody is going, that's not what we stipulated to. I'm allowed to go to all of her activities, and now I'm not allowed to because
is there
somebody
any
is
problem,
allegedly
is
accusing.
there any problem you guys sitting in different sets of bleachers and not speaking to each other?
That's fine.
Judge, I don't
But Mr.
understand.
Perry has said he would remove the child if I even show up. I sit in
You
the
know,
outfield.
basically, and I always go back to, I just remember which,
I'm sorry I asked.
he'll remain nameless, but he was sort of a no-nonsense judge from 20 or so years ago. He says, I'm not gonna interfere, he said, I'm not gonna deal with this childishness. I'm not gonna interfere with parents' constitutional rights to interact with their children at school or at events. If anyone's a jackass, they'll get arrested, and that's them if they can't. So on the other hand, I sort of agree with that, and on the other hand, say, if we can avoid conflict, of course, let's do it. But I don't avoid conflict at the cost of saying, because I accept the fact that people are gonna behave badly, which I don't, I'm depriving each of them the ability to attend a school play during one parent's time, a baseball game during another parent's time, ballet during another's. It's absurd, I can't do that. I just have to accept parents have that constitutional right, and I have to allow that right rather than protecting against the fact that someone may be a jackass and get arrested. If one of them wants to confront the other, I'm sorry.
And if Ms. Hurd chooses.
That said, I think at medical appointments, we shouldn't have these two in the same room, but at a sporting event with hundreds of cubic feet of seating and all,
Judge, I don't think you're hearing an argument from us. I think.
Pardon?
I don't think you're hearing an argument from
Oh,
us. I
oh,
think
good, good.
what the defendant is saying is that she wants to attend anything so if my client chooses to not attend an event because Ms. Hurd announces that she's going to be there and he's looking to avoid conflict, she's looking for you to compel my client to attend.
No, I never said that.
No,
I said
well-
I want to be able to attend. Mr. Perry has said he would remove the child if I show up to her games. In fact, I had missed 2 games because he had the child,
Okay.
and if I attended, he would remove
What
the
he-
child
he's-
from her activities.
He's in,
That's coercion.
When you talk about her activities, you're talking about she plays in Miracle League.
And hopefully
That's-
ballet.
that-
She needs to be involved
If
in
you'd like to
more.
put her in ballet, then you're free to
You
do
see,
so.
the issue is, we can't say you can attend event because dad takes her to a movies or drops, or is gonna pick up a couple of her school chums and take them all to see Quest or something. That's not what we're talking
No, we're
about.
not-
You don't,
we're talking about
you or him
separate-
don't have the right to
Yeah,
interfere with
right,
that.
I
But if
agree.
it's a formal event or lessons that she's
Right.
engaged in on a regular basis, that's different.
The
And
season
They
of
both have the
Perry
right
has
to
stated
attend,
that if I
and
show up,
if I
he will
start,
remove it.
as much as I want to badly avoid conflict, I think if I start saying you can't attend during her time and she can't attend during your time, I accept the premise that if we keep parents apart, it solves the problem, rather than solving the behavioral problem where you are an adult, and if you act up, you could get arrested, and that could jeopardize your employment, your
Nobody has
custodial rights,
requested
etc. People, I can't guarantee, if we can't solve conflict, we're not gonna solve it by saying, you don't have the tools to avoid conflict, so we're just gonna keep you away from each other. That's two parents who need to, and two parents who need to raise a child, a special needs child, for me to just say, you never have to have mature contact again because something bad could happen. I don't accept that premise. I'd rather say you both have the constitutional right to enjoy your daughter during these
They both have the
activities. And
constitutional
if someone wants to act like a jackass and get themselves
To
arrested,
attend or
I
not to
can't do
attend,
anything
correct?
about it.
To attend or not to attend.
Right,
That's all,
Right.
agreed, stipulated. That's what I'm saying,
Right.
there's no request from us.
Okay, but Mr. Perry has stated via text that he will remove
I
the
think this is
child.
what she's talking about, that if they see her in the bleachers in the audience,
They're gonna
that
leave.
he would view it as, he's obviously viewing it as a protective mechanism, or to conflict avoidance. She views it as some passive aggressive type play, and I don't know how you'd classify it.
Well,
So,
I can tell you that Miracle Week is over for the year,
Right.
it doesn't even resume
Right,
until
but that doesn't-
sometime next year. If Ms. Hurd wants to enroll the child in an extracurricular activity during her time, she's free to do so. If she wants to provide my client with, information about that, he's happy to receive it. I don't know whether he will choose to attend or not.
well,
and I don't
fair
think
is
any
fair in the
orders from
sense
this
if
court.
someone wants to remove Aslan from an activity, they can't blame it on the other parent. You're being deprived of this activity because they have to take responsibility. I am doing this because your mom or your dad attended. I don't think either of them are fair enough or mature enough to say that. They'll just blame it on the other parent. You gotta own it, even with an 8.5-year-old. You gotta own it and say, this is a decision I made.
I
And
know
I'm
my
not saying
decisions.
it's necessarily a good decision, it's the one I think I have to make now. And they have to take responsibility. I don't know, I had to do it because your mom showed up or your dad showed up, no?
I'm always taking responsibility for my actions, good, bad, or indifferent,
So-
Your Honor.
And I think as you're saying, this is much ado about very little, because
It is.
although mom is adding some commentary which threatens to sink the ship, the fact is, as you say, we have the framework of an agreement here, so let's repeat it, go ahead.
Okay.
So, the motion to set aside is denied.
Well, I mean, on this,
Oh,
that's all been, you
Okay,
handled
I'll
it.
just- okay,
Right.
so you're talking about the.
Right. The holiday
timeshare
plan.
change?
And what else is on tap for January 14th, the so-called restraining order?
Judge,
You may run into,
the motion
the
and
problem is
motion
you
that
may
we
run
just
into a
filed.
judge who's gonna issue a mutual restraining order against both adult females if they can't determine that someone's 100% at fault. I don't want them to both be facing that, that's permanently on their records. It can affect employment, future employment undertakings, security
Why don't we just
clearances,
stipulate to a
future
mutual behavior
custody
order?
matters, et cetera, et cetera.
We just stipulate to a mutual behavior order.
That probably would be appropriate. Do you wanna just agree to a mutual behavior order? The terms are all written down there.
I would wanna see them specifically before I agree to anything.
But basically,
But
it
basically,
basically
Among
reiterates
other rights-
everything you want and more about,
as long
you
as
don't wanna be contacted.
Carrie
you
is
don't
not around me, I'm okay with that. I just
Okay.
don't want her around.
Maybe
And
it's
she
an
doesn't
easy
have any
fix
rights to
then.
be around. That's period, end of story. I'm the mother. I have the constitutional rights.
Right, but it's a little more complex
I get
when
that.
someone he married or someone you marry is gonna have access to your child a good chunk of the time because
Here's,
obvious.
here's the only issue, Judge, as we've said, we're not looking to preclude anybody from attending something that they want to attend, okay? But the issue that I could see, as I understand it, is there's a graduation ceremony, there's a game, something of that nature, okay? And my client and his wife are there, and the defendant chooses to attend. Now, is the primacy going to be that if she can get herself geographically there, that then Gary's forced to leave, or is she violating the behavior order by showing up, right? So that's the issue.
It's my child.
Okay, it is, I will state for the record.
Bitch,
but-
shut
It's
up.
complicated than
I
that because
understand that.
you both have a right to introduce other people
We
into your
do,
life.
But not to
You-
the
you
exclusion of
may
the other
want-
parent.
No, but
I don't have a right to introduce a father to the exclusion of Mr.
no,
Perry.
but you have the right to introduce a stepdad who's going to be
Right. Not to the
interacting with
exclusion-
your daughter and is going to
Exactly.
be involved to some extent.
Not to the exclusion
No,
of Mr.
of
Perry.
course
And I,
You are not being excluded because he introduced a stepmother. You are being excluded because you are a straight up crazy ass bitch who cannot control herself.
they're introducing her to the exclusion of me.
Well,
That's
Well,
my issue.
Whatever their secret
To be fair, Judge,
diabolical motivations are, we can't reach that. We can only reach to protect
To
you
be fair,
from
Judge,
that with the order.
The defendant is the one who came and said she wanted Carrie 1,000 yards away from her, right?
Right.
Which
The
is-
court said that. That we're to remain
Well, how do we do that if you both want to attend the
what
same
I'm,
event?
that's what I'm saying, is that no, so to say that somebody's trying to excise her from.
Exactly. We need stronger language. Stronger language.
Right? It's a
How should it read about the, okay, I'm gonna leave you guys for a minute, because what we need to discuss, so we can at least vacate the January 14th, so a new judge gets a clean slate and doesn't have to be, it can be dealing with the main issues and not these collateral issues.
There's no
Quarterly
new
notice.
judge.
You need to deal with the holiday situation, because you could have your best friend as a judge, and it doesn't do you any good once the holidays have passed. That's number one. Number two,
I think there
a
are-
lot can happen between now and a few months down the road if we don't have precision. I think a behavior order is probably the way to go. We can show her
I
we
believe
can
one was
show mom a
submitted that was
copy of what it
agreed-
would look
I
like.
think there was one that was agreed to and submitted to the court well before trial. I don't know
Okay.
if the court signed it. I'm
And
confused with
since
that.
since mom will be doing the Mondays and all the appointments, this is sort of connected to the behavior or protective order issue in that eliminates these two from each other,
It
kind of,
does,
right?
and that's to the extent, yeah, it does, and so I would agree to
Okay.
that extent.
Because I'm a little concerned about issuing restraining orders as opposed to protective orders, because restraining orders have much more serious consequences in life, so. Now, about so I'm gonna leave you guys to discuss, and then you deal with, if I succeed in the recusal, you deal with the new judge about whether any modifications, you probably, the current motions are not in the form of modifications, but set-asides, and the court's unable to set aside for the reasons
understand that.
elucidated. Now, but what is on tap for January 14th is the holidays, which you should be able to resolve, keeping mom and stepmom from each other while still everyone having the same right to attend Aslan's activities, medical, etc. And the third thing mom was talking about is Skype or telephonic contact. What's the specifics about that?
I mean, currently mom sees the child Wednesday, Thursday,
Wait,
overnights,
he
and
said
Friday,
telephonic,
weekend.
that's what we're talking
Or
about.
Skype or
Well,
video
I'm
or
trying to-
what?
Yeah,
Well,
FaceTime. I'm not
Okay.
allowed to contact her, and
Okay,
the
what would,
stipulations
under
is
the
liberal.
current schedule that the two of you seem that you'll agree with, what would be a fair FaceTime schedule for both of you? Each day?
Yeah.
Okay,
Yes,
what time? These two probably don't need to be in regular,
Judge, I see okay,
no, you're right, I mean, you know.
it just seems to me that
that's what's in the
you have
stipulations, if
3
we're not
days.
setting it aside, that's what I'm allowed to, that's what.
Next time he sends her to Miss Hurd, he should have her dressed with a "I love my stepmom" T-shirt with her stepmom in the picture.
Was stipulated to. It's in the
tell you what.
stipulation, Your Honor, literally.
Yeah, if we're, since the court's not disturbing the
I'll tell you what, Judge,
stipulation,
Yeah.
I'll tell you what.
That's-
but you
Let
could
her-
discuss
let
a
her-
stipulation
let her
change to
buy-
FaceTime if
If she
you
wants
want.
to supply Aslan with a cell phone,
Okay,
then my client will ensure that the child has it, and she can call her and conduct communication with her directly.
okay, so I'm gonna leave you guys to discuss the holidays, the restrictions or lack thereof about attending events. And if you wanna stipulate to change the FaceTime, that's fine, but as she says, if you don't, the order is the order for now,
Which
so.
allows me liberal communication.
Okay, so,
That's all I'm
you
asking
ready
for.
to have the
Liberals, not
discussion?
4
I'm
times a
happy
year.
to try and have that
Okay,
conversation.
thank you. Thank you. Very good, we're back on the record. Appreciate everyone taking some time to discuss matters.
Breathe, breathe, breathe. We have 25 more minutes of this whole case. So, no matter what happens in the next 25 minutes, there might not be any screaming at all. The lawyer might just go through all the stipulations again, which takes 19 minutes, and the judge might just sign it. And then we're done. We don't know if there's an ending to this. There's never going to be an ending to this, actually. So, 25 more minutes. Here we go.
Thank you, Judge. I think we have a global
Oh,
on.
wonderful. See, twice in a row when I remove myself from the equation, things get settled, see?
If we
I have
can,
to, I
can
should
we
do that
please-
more often.
Yes, Judge. Can we swear the parties in?
Please.
Please stand, raise your right hands to be sworn by the court.
You and each of you do solemnly affirm that the testimony you're about to give in this action shall be the truth, the whole truth, nothing but the truth, under penalty of perjury?
Yes.
Thank you so
Now,
much.
before we begin this, of course, the court's guardedly optimistic things go well. A couple observations, which I just made the first one, when the court removes itself from the equation, that seems to help a lot. Secondly, though, we don't want this to go sideways like the first one. How do we avoid that? Restrictions to keep mom and stepmom as far apart as reasonably possible while not impeding the ability to parent, et cetera. So I assume your global resolution includes
I
those
believe
provisions.
so, Judge.
Very
I
good.
believe that it does. So I wanna make it clear, so the record can be as clear as possible. We put to bed the motion to set aside, we're going to prepare an order with respect to that.
Cookies take 9 minutes to bake. We have 24 more minutes. Yes.
An order of this court. I will circulate that to the defendant, that motion is denied. She will have 7 days from the date that she receives it to provide me any commentary or requested revisions. Obviously, I don't anticipate that will be necessary, but if they are, we'll make anything reasonable.
So you're gonna have separate orders, or?
I'm gonna do one as a standalone order on the motion to set aside, and then I'm going to do a stipulation in order with respect to what we're discussing right now.
Which also reiterates that separate.
Correct,
Okay,
correct. It will reiterate it, but it will be two separate orders. Okay.
excellent.
So, as far as the stipulation and order,
My bad. I'm sorry.
those items are affecting, and I wanna be clear, there's sort of two categories, Judge, and part and parcel of all of this is that all of the motions currently scheduled in January as part of the stipulation and order will be vacated.
So we'll go ahead and vacate January 14th. Yes.
All of those motions, which I believe I've confirmed with Madam Clerk, that will leave no motions pending before any court.
And once that's removed, that's it,
That is correct,
at this time.
which I'm doing right now.
Certainly, nothing precludes either party, hopefully they won't, but nothing precludes either party from filing something in the future to modify or whatever they may do, but that would conclude where we are for now. Is that clear, Ms. Hurd?
That's correct.
And you understand that as well? Yes. Okay. So the first category that I'm going to discuss are going to be the holiday plan deviations or modifications, as well as provisions regarding telephonic communication. These are going to be permanent orders, meaning they will be incorporated within the existing order. They will modify that order to the extent that they change it, but they will be final orders that would require, obviously, a finding under Romano to modify and best interest in, material change to get there. Okay? So what we've agreed to do with respect to holidays is, with respect to the Christmas break, it will be divided into two segments, segment 1 and segment 2. Segment 1 is going to commence Friday when school recesses for the winter break, and it is going to continue for the duration of that weekend through the following week to Saturday at 10 a.m. The exchange point for the end of segment 1 and the beginning of segment 2 will always be that second Saturday of the break, 10 a.m. The second segment will commence at 10 a.m. and will conclude with the child's drop-off at school when school resumes. The parties agree and they understand that in looking at the calendar, it may well be the case at some point that this division does not accomplish ensuring that segment one always has all of or even any of the Christmas holiday. They also understand that depending on where the school district does its calendar, the second segment may sometimes include a Monday and a Tuesday if that's where New Year's Eve falls and the school goes back on Wednesday, but they understand that. This is the segmentation that they want, and they want this to be permanent, irrespective of whether in the future it may be the case that, oh God, I'm supposed to have segment one and it doesn't include Christmas, or segment two is extra long because of New Year's Eve and New Year's Day fell on a Monday, Tuesday, that type of a thing, okay? The designations for that will be as follows. Christmas, and I believe these are consistent, they haven't changed from the order, but I'll reiterate them. Christmas segment one, in even years, will belong to mom. In odd years, it will belong to dad. Christmas break segment two, in even years, will belong to dad, and in odd years, it will belong to mom. Okay? We have provided some further delineation with respect to 3-day holidays. The first of which I'm referring to as Friday holidays, though I believe the only one that comes to mind is Nevada Day, but we're just gonna say a Friday holiday from school. If there's a Friday holiday weekend, that holiday weekend, and the designations in the existing order will not change in terms of even and odd, it will remain the same, but we're specifying that 3-day weekends where Friday is the off day from school, we will commence the holiday weekend Thursday at the conclusion of the school day, and it will conclude on Monday at drop off to school. Okay? For all Monday holidays, again, the even odd designations will remain unchanged, but we are going to specifically define those holidays as 3 p.m. on Friday when school, or really at the end of the school day. So typically around 3, but it's going to be the conclusion of the school day, meaning the parent will be responsible for collecting the child from school. And the holiday weekend.
Be right back.
will conclude at drop-off
Be
to
good.
school on Tuesday. Okay. We are changing the designation of even and odd with respect to the 4th of July holiday. Going forward, mom will have the odd year 4th of Julys. Dad will have even year 4th of Julys. The 4th of July holiday will be defined as commencing at 10 a.m. on the 4th of July and concluding at 10 a.m. on the 5th of July. Parties are going to define Halloween as a single day holiday. I'm suggesting that we haven't discussed this. I think this provision should only apply, I'm gonna ask you both to tell me what you think, but I think this provision should only apply where Halloween doesn't fall directly over the 3-day Nevada holiday weekend. So if Nevada Day is a Friday and Halloween is that Saturday, then we're not gonna have an independent Halloween. But if you have the 3-day weekend, Halloween falls the following Tuesday or Wednesday, which I believe is what happened this year, then you'll have a standalone day for Halloween. Is that clear to you, Mario?
Halloween will trump the 3-day weekend, is that what you're saying?
Opposite.
Wait.
The 3-day weekend.
Oh, yeah, so that would be next year.
The
So that'll be
3-day weekend will trump. So if Halloween is contained within the Friday,
Which will be
Saturday,
next year.
Sunday,
Right.
then whomever has the Nevada Day holiday weekend will have Halloween.
That's fine.
If Halloween falls outside of the 3-day Nevada
Okay, so
Day
next year,
weekend,
that will be me. Is Mr. Perry aware of that?
I
Can we
mean,
still
it
agree
is-
to that?
It is what it is. I know you had Halloween this year, he understood.
Well, he actually allowed me to have it, but he had Nevada. So next year, 2025, Nevada Mission Day will be Halloween. It will be Friday the 31st, and that will also be that holiday weekend.
Usually, I always say when
Because they do.
I always say that Nevada Day the day before.
Yeah,
The
it
week
moves, it's
before.
always that Friday.
It's usually a Friday.
If it happens to fall that way, is it pretty fine?
Yeah, and
It is the last Friday, and it looks like that, to her point, that may be, in 2025, the last Friday,
So,
looks like it is the 31st.
no,
So if that is Nevada Day observed, let's see if my office doesn't show it, let's see if we
So
have.
I would say if you have that 3-day weekend, say Nevada Admission Day, so 2026.
well, it was that's fine, cause she'll get,
He would have her.
I had Nevada Day this year, she'd get Nevada Day next year.
It's just.
But then
she's
he would have her
indicated
too.
it's
Actually, it
assumed
kind of
holiday.
goes
And she'll
consistent,
get
so.
Halloween.
Okay.
So look,
Yeah, I would agree to that.
the Nevada Day holiday
Okay.
for the 3-day weekend will take precedence, If Halloween does not fall
Got it.
within those 3 days, then it will be designated as a single standalone. And in those specific years, Halloween will commence after school, or if school happens to not be in session, and unlikely given the fact that we put it into the weekend, then it would be 3 p.m. through drop off at school or 9 a.m. on November 1st. Okay? With respect to spring break, we're changing the designation. Even
I'm back, and the lawyer's still talking. That means I called it a little bit. I called it. He's going to read for a bunch of minutes, no yelling, and the judge is going to sign the order.
So Dad will now have even-yeared spring breaks. Mom will have odd. Spring break will commence the day that school recesses for the spring break, and will conclude at noon on Sunday before school resumes. The parties have agreed that noon will be the exchange time unless whomever's holiday is traveling with the minor child and has, obviously, in accordance with the order, provided a travel itinerary evidencing such travel, in which case they will have up to 6 p.m. with proof of the travel if they're out of town with the child, to allow for some flexibility for the travel. The final one is a permanent modification, but it is a single year only as an accommodation to try and resolve the Thanksgiving holiday. So for the 2024 Thanksgiving holiday only, the parties are going to effectively divide that Thanksgiving break. Dad will have Wednesday at the conclusion of the school day through Friday at 12 noon. Mom will then have Friday at 12 noon through Sunday at 6 p.m., which is Sunday, December 1st. And that is a single standalone for just this Thanksgiving. Mario, you heard the specifics of that holiday timeshare and the specific changes that were made to the order that is currently in place, correct?
Yes.
Okay. And you understand that unless I specifically mentioned a change of even or odd or a change of time, that this is the totality of your agreements regarding holiday visitation.
Yes.
You understand that these are going to be permanent orders of the court.
I just found out there is a National Pennsylvania Day, and I love it because it's in July. Yes, it is. July the 20th.
Meaning that any requested modification would have a burden of proof, and you would be required to come to court and put on evidence to reduce the best interests of the child, warranted a modification from these agreements.
Yes.
And with respect to that, you would ask that the court accept and adopt these amendments as its final order regarding holiday visitation.
Yes.
Okay. Similar
They're
questions?
still agreeing to the regular weekly modification with the
I'm gonna get
Monday and
there,
the
Judge.
3 things.
I'm gonna
Okay,
get
very good, very good.
With respect, Ms. Hurd, you heard the questions that I asked Mario. You heard the totality of what I placed on the record, correct?
Yes.
Okay, you understand that unless I specifically mentioned a deviation or a modification, that the existing holiday timeshare contained within the stipulated orders of this court remain in full force and effect, correct?
Correct.
And only those items that we address specifically here will be changed, correct?
I agree.
You understand specifically with respect to the Christmas break, and I admonished you both about this, that is permanent order. We're doing that second Saturday at 10 a.m. division, and that is irrespective of whether it fully encapsulates a Christmas
July.
holiday either
I
setting.
agree.
You understand that?
Yes.
And then specifically, that will not serve as a basis to modify or remake the Christmas visitation.
Agree.
You heard those questions I asked her?
Yes.
You agree to those as well?
Yes, sir.
Okay. And with those agreements, Ms. Hurd, you would ask that the court adopt those as its permanent orders regarding
For the
holiday
holiday,
visitation.
yes.
You
I agree to that.
recognize that those are in the minor child's best interest.
Yes.
Mario, you also recognize those are in the minor child's best interest.
Yes.
Okay. Judge 2, the provisions that you were discussing when you first took the bench. So, in an effort to accommodate the concerns over Ms. Hurd and Ms. Opapari and their engagement, what we've agreed to do, Ms. Hurd would like this to be deemed a, and we will note this in the way that we spell out the stipulation, a temporary modification of the parenting timeshare. What we are going to do is give Monday, each Monday, after school, through 6:30 p.m. to Ms. Hurd. Ms. Hurd will be responsible for collecting the child from school. She will be responsible for making sure that the child attends her therapy appointments. Nothing will prohibit Mr. Opapari from attending those if he is able to, but it will not be a situation where Carrie will attend those appointments on her own. Ms. Hurd will be the one taking her. Ms. Hurd will be there for those appointments. With respect, and that will be a temporary modification of the timeshare. With respect to the balance, Judge, of precluding people from being around one another, the reality is, and this would be a statement to the court, and I don't know, Ms. Hurd, if you would disagree. I can tell you that it will not be, Carrie will not, if there is an appointment or, scheduled by the defendant, Carrie will not take it upon herself to go to that appointment and meet the defendant and Aslan at that appointment, a one-off or a well visit or a dentist appointment or something of that nature. If there is a well visit or a dentist appointment or something of that nature on Mr. Opapari's time, Carrie may well take the child to that appointment. If Ms. Hurd chooses to go there, she's choosing to put herself there, she has every right to do so. But we're not going to have a preclusion on Carrie's ability to take the child to a doctor's appointment or a dentist appointment scheduled on Mr. Opapari's time. Certainly she'll have notice of the appointment.
Why can't I just take her?
If you schedule an appointment on your custodial time because the child needs an appointment, or if the child's sick, you certainly can.
But I don't agree to Carrie taking her to any appointments. We agreed to this Monday, right? And then, I wanna make clarification.
Shouldn't the Monday issue eliminate
It does.
85% of it?
That's
Yeah,
correct, Judge.
so I have when on my weekend, when I get her on Friday, I will now go till Monday at 6:30. I don't have to give her back on Sunday at 8 p.m. to go get her on Monday to give her back, right?
No, it's Friday to Sunday at 6, and I'm gonna get to that. Yeah,
No, Sundays were at 8,
no.
but now,
No, we,
that's what they always were.
okay, but we specifically discussed, yes,
We didn't
I
talk about
assure
this.
you that we
And why would I
did.
give her back on Sunday night to go get her back Monday to
You're
take her to
picking her
therapy?
up after school, and
Right,
you're
so
having
my
a
weekend
3-hour
should just go
visit.
from,
No,
that's what the judge even suggested, my
No, we're
weekend should
not.
just go from Friday to Monday now.
No.
And I'm not gonna
no,
reduce
we're not
my
gonna,
time.
you're not reducing your time, you're getting time. You're picking up every Monday after school till
Okay.
6:30 to alleviate your concerns over Carrie
Okay,
taking the
That's
child to
right,
her
that's on
therapies.
Mondays, but now on my weekends that I have Friday at 3 p.m.
Till
Instead of
Sunday at 6.
returning to no, my
It
Sundays
was
are
Sunday
8.
at 8, and what I specifically said was
And
to
then I should get her-
accommodate the Monday after school, we were gonna roll it back to 6 p.m. I said that repeatedly when the
No,
judge was
I
on the
don't
bench.
agree, no, I don't agree with that, I should just keep her Sunday night,
Okay,
and then
well,
I'll
then we-
exchange her Monday night at 6:30. It's so
The
much
answer
easier
to that,
for
the
her.
answer to that request is no.
Okay, I would like the court's discretion,
Judge,
court.
this is,
I thought this was,
it was. I
I
said
thought
it
that
7
was, I
times.
thought that's what we
I
said.
said it no. Ms. Hurd, I promise you, and
I'm not
if
gonna
you were
give
to
up
look at the
time.
video, you will see what I said 7 times on the record was that we would give the Mondays after school. And I said 7 times the exchange for that would be,
No.
her weekend 2 would be Friday, Saturday, and Sunday, and we would roll it back from 8 p.m. to 6 p.m. And I said that repeatedly.
why don't you just set all the appointments during your time and you eliminate the issue?
Because
If possible.
this Monday appointment has been set for 4 years, since September of 2020.
And you're
it's
taking her, right?
It's 3,
And you're
yeah,
taking,
but why do I have to give her back on Sunday at 6 to get her on Monday? Why don't I just keep her on my,
so
on my
is it
weekend,
about
only on
giving
my
back
weekend?
Sunday at 6? I
It's-
thought it was about this issue of who gets to attend the,
That's what we thought as well, Judge, which is why we
Right, but
came
I
up with
wasn't
the proposal.
aware, I thought I would just get her from Friday to Monday then.
That
Why
was
do I
never-
have to,
that was
that doesn't make
never-
any sense.
No, what you're doing respectfully is you're arguing for more when you know we had a specific
was it
proposal.
agreed to a Sunday night or a Monday morning
I-
delivery to
Judge,
school?
You can
was?
watch the
Or-
video. I assure you what I said
Then I
repeatedly was to
misunderstood.
accomplish the every Monday, so she could, because of the stated concerns over Carrie taking the child and her showing up on Mario's custodial time to be at the appointments, which she is fair to do, my client said, tell you what, how about she can have those Mondays after school, take her to the appointments, bring her home at 6:30. And he said, what I would ask is that Sunday evening on that weekend too, be rolled back to 6 p.m. so that I can have a little bit of a Sunday night. And I said it 7 times.
But he gets every other Sunday night anyway, so
You
why
can
not?
agree to that, or you can keep it where it's at,
Right.
which means we have this dilemma, which I can't solve
This is a
about.
temporary
Then
modification,
you don't,
so
yeah,
that's
you don't
fine,
want
that's fine.
three, you don't
For
want three,
Terms of temporary.
you don't want to
So
agree to
here's-
anything
fine.
that's gonna keep
Here's
you
what concerns me.
dealing with the 3 sessions on Monday, so
Right.
you should probably be going with it, but.
Okay, that's
I
fine.
wanna
Let's
say-
just
Okay,
do
I
that.
let's
wanna
proceed,
say
agreed,
again-
let's proceed on with the rest of the
I wanna say
agreement.
again then-
Let's
I
proceed
wanna
with
say
the
again
rest of
then-
it.
Got it, okay, let's
Very
just
good.
do that.
Let's
Let's just
proceed
do it.
with the rest
I
of it.
wanna state again then for the record,
It is
that
a temporary modification.
doing
that's
this
fine.
temporary modification is in no way my client admitting, conceding, or validating in
The
any
court
way.
already made it
I
clear
understand,
what
but I
its
have-
ruling was, and you can include the language,
have
how it
something.
ruled, the court's unable to set the agreement aside, but a modification based on subsequent major occurrences is always a possibility, like it is in every case. I think that he's fully protected on that issue, and so is she. She's protected as the existing agreement. She's protected if there's anything major that justifies changing it, so it's about as fair to both as
The
can
last
possible.
piece, Judge, pertained to, and this will also be incorporated in the permanent part of the stipulations, set aside from that minor timeshare deviation for Monday after school to the defendant, is going to be the telephonic contact. Parties have agreed that in any day, that it is so essentially the non-custodial parent on a given day, in any day that a parent does not have any contact with the child, that parent is entitled to a telephone call of no greater than 10 minutes in length from at 7:30 p.m. on that day. We've agreed that there will be about a 10-minute flex north or south, meaning 7:20 to 7:40. And it'll be a 10-minute call, and it's for any day that the child is with defendant, the plaintiff does not see her that day, or that the child is with plaintiff and defendant does not see her that day. That call will go forward. Parties have agreed to the greatest extent that they possibly can, that in the event that a call, for whatever reason, is unable to go forward, there's a car accident, there's an illness, something of that nature, that they will notify the parent as soon as reasonably possible that the call cannot go forward. And that is the totality. Mario?
Okay, just have 2 quick questions. Number 1, it sounds like this adequately handles the mom and stepmom issue.
I
right?
believe
Okay,
so.
number 2, I may regret asking this, is there a resolution on child support? Or?
I don't, I think, the bottom line is there is an order. If the defendant wants to present me with what, she's already stated what she thinks it is, if she
Okay.
thinks it's in a letter somewhere, and, she wants me to discuss
When she
that.
reacts to the orders you send her, and she can include in the email any
That's fine.
suggestions
If she
relative to
If she
that.
wants to do that, that's fine. But we're not gonna disturb the existing order. What I'm simply doing is one standalone order codifying this court's findings and rulings with respect to the motion to set aside. And then I'm doing a separate stipulation order, which is the product of this prove-up hearing, setting forth the permanent additions with respect to telephone contact, the permanent modifications with respect to the holiday schedule and holiday visitation, and then the temporary modification of timeshare with respect to the Mondays after school.
She wasn't interested in the cell phone suggestion, which would give her regular direct access.
But we decided to go this route,
Okay,
and that's what
okay.
it's going to be.
Okay.
With respect to the provisions regarding telephonic contact, Mario, did you hear them?
Yes,
Okay, and do you fully understand what that order will be?
yes,
Okay, you believe that order to be in the minor child's best interest?
yes,
Fully intend to comply with that order?
yes,
You ask the judge to adopt that as a permanent order of the court?
yes,
Same questions for you, Ms. Hurd, you heard the provisions regarding telephonic contact?
Correct,
Believe that they are in the minor child's best interest?
yes,
You ask that the judge adopt those orders?
yes,
And you fully intend to comply with those orders once adopted?
correct, yes.
That's a different photograph than that.
Yeah, that's your new one.
It's very nice. Thought it was a different one. What else do we,
Your Honor, I guess for the record, since this did come up, Judge, in some of your canvassing, Ms. Hurd, you're not ill today in any way?
No.
Okay, you're not under the influence of any substances or medications that would
No.
affect your ability to competently testify? Okay, so the testimony and the affirmance of all of the provisions we put on the record are made with sound mind and the full intent to be bound by them?
Correct.
Okay, Mr. Opari, you're not ill today?
No.
You're not in any way diminished in capacity because of your use of alcohol or any medications?
No.
Okay, and so the amendments that you made to these specific agreements were made with sound mind?
Yes.
Okay, and they were free and voluntary?
Yes.
Ms. Hurd, these were free and voluntary?
Yes.
You were not coerced into these
Not
agreements?
today.
Okay, but you were not coerced into these agreements?
Not today, no, I wasn't.
The implication is you were previously, but the
It's
simple
okay.
question is, well, okay. So, with that said, Judge, I would submit to your honor. Ms. Hurd, can we just have on the record, what is the email that you want me to send the, both the draft order denying the motion to set aside and the stipulation and order that we just put on the record?
The email is Joy K.
Kimberly Joy at G.
Great work, guys. It ended a lot better than it began, so great work. But is there anything else we need to? The
That's
court
it.
obviously accepts the stipulations.
And
Very good.
adopts them. Thank you,
Thanks so
Judge.
much.
Thank you.
Thanks, everyone.
Wow, it just ended just like that. And now it's over. It's not really over. There's definitely more cases. But I'm just going to, here's what I'm going to do. Real quick. I know we already went over time. But I'm just going to give you a sneak peek of what we're into next. I'm just looking at the size of the videos real quick. 8 minutes, 2 minutes. So this is only going to be a couple days long. It's not going to be as long as the first one. Let's just look. Actually, let's go here.
Go on the record.
And here. Oh, wait, what's that?
However far out it is that he was requesting, I mean, he
It was 1 week.
No, it's
It was,
longer.
it was 1 week, and his client has a right to counsel.
His client isn't here either. Nobody's here. And he's,
Right, he was.
All right, good times. Different judge, same courtroom. This is going to be awesome. Is it? This is just what I think I need for our Facebook campaign. Yes, she does have great hair, but she doesn't have any stuffed animals. So no Groot. Maybe we should mail her a Groot. Maybe we should mail all judges a Groot. Maybe we should just mail everybody in the world a Groot. Alright, guys. Thank you so much for enjoying this whole case with me. That was way better than I thought it was going to be. I can't wait for the next one. Beck, thank you so much for sending this to me. You're the best, keeping us entertained. I don't know, Welsh lady. I have no idea. Yay to more shenanigans. They're probably in court today, and it's a Sunday, so. Alright, guys. Behave, and I'll see you tomorrow with this and OJ. Have a great Sunday, guys. Bye.
Got these lights that close digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor charm. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes hear a sky so blue. In her jokes there's a truth so true. With each string she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh